Yes, good afternoon, all of you. So, have you revised the things and come, or you haven't seen anything at all? Hmm? Did you find the class useful? So you didn't find it important to revise because you have everything mugged up in the class itself. Okay. Anyways, so we'll start today with the fundamental rights. Okay. In the last class, we have discussed preamble. Okay. Then we have discussed the state and union territories, its formation, state reorganization, etc. Okay, and things related with that. And finally, we have seen the citizenship. Okay, so we have started from preamble, then Article 1 to Article, yes, 11. Okay, so fundamental right, this is the part 3 of Indian Constitution, and perhaps the most important part of Indian Constitution. For a reason, it establishes the rule of law. Okay, so that's the most important aspect. So let's begin with the chapter, that is a part 3 of Indian Constitution, that is fundamental rights. Now, before moving into that is formal beginning, this is from Article, yes, 12 to how much? 35, yes. So this is called as part 3, and fundamental rights and article are there. Yes, now before beginning into this constitutional provision, okay, let us understand that some theory of the rights, rule of law, what is its nature, okay, a very brief background in order to understand what is the position of fundamental right, what is its important in Indian Constitution, or for that matter, what is the position of the rights in any country, okay, and depending upon that, what are the different types of rights. So first we will understand the meaning of rights, what are the rights, then we will see that what are the fundamental rights, what are the fundamental rights, then we'll see what is the rule of law, what is the rule of law, and how fundamental rights help in establishing the rule of law. Okay. In fact, we will see what is constitutionalism also. Constitutionalism. Okay, these are the basic things for any polity. Now, first, let's start with the rights. Yes, can anybody define the rights? How do you define the rights? What are the rights? Yes, what are the rights? Anyone? Rights are? Claims. Okay. If I claim that it is my right to murder someone. Yes. Any claim can be a right. I can claim anything. I am being a part of society. So if it is a full liberty. So, yes. Basic conditions required for survival. Okay. That can be the basis. Yes. This has to be sanctioned by law. Okay. Anything else? Sanctioned by law. What do you mean by sanctioned by law? Claim sanctioned by law means? What is the meaning of it? Restricted by law? Okay, directed by law, enforced by law. Okay, there is a backing. What else?
So ensures coexistence.
Ensures coexistence. That's the utility of the rights. Okay, you can write the definition. Rights are reasonable claims. They are not any claims. These are the reasonable claims as recognized by the society. As recognized by society and guaranteed and protected by law. Guaranteed and protected by law or enforced by law. Guaranteed and enforced by law. So there are three different things. That is, these are the reasonable claims. So any claim cannot be your right. and what is the reasonable can be the society. Okay, there will be obviously a consensus what is acceptable in the society and what is not acceptable for the society, what is good for the individual. So there will be more or less consensus within the society that yes, this is accepted for the freedom of individual, existence of individual, for the good life of individual. Now again, see, if the first step and second step is over, and if the third step is not there, even if it is recognized, still it has no meaning, because tomorrow, if somebody violates something, somebody is right. So there is no enforcement mechanism behind it. So it is very important that the right should have all the full characters. That is, there should be some authority, adjudicator body, in order to like guarantee and protect such rights of individual. So in case of a violation, okay, of such rights, that whoever is the adjudicator, okay, say for example, court in India, so that adjudicator will help in enforcement of the rights. Okay, now again, when the society is having a recognition of the rights, there can be a different variety of the rights. Okay, these are the different variety of the rights. So we will see what are the fundamental rights and what is the rule of law. We will come to fundamental rights little later. Okay, let us understand what is rule of law and what is the relationship between the rights and the rule of law. Okay, so just we'll see that what is rule of law. What is rule of law? And in this context, we have to see, because this is the nature you have to understand the difference between the part 3 and part 4. Okay. Yes, what is the rule of law? Yes, anyone? What's the rule of law?
So nobody is above law, everybody is equal before law. It's
Oh,
very particular.
okay, that is Dice's principle. Dice's principle is very, very specific. I want a very generic meaning, okay? That are the very specific parts of the law. Like say, for example, Article 14. What you are saying is about Article 14. Equality before law and equal protection of law. These are the later parts. Rule of law is a sort of a big ideology. It's a sort of a constitutionalism. Yes? Is the meaning. Why at all we have the rule of law? What is the opposite of rule of law? Huh? Anarchy. Okay, so anarchy, somebody will be there. Okay, in an anarchy, what happens? Then whoever, might is right. If there is an anarchy, what happens? There is a might is right. So there is a possibility of authoritarian government or dictatorial government. So if the rule of law is not there, then obviously, as you have said, it is anarchy, and obviously the people are there in the society. So whoever is the strong, he is going to rule. So it will be the rule of men rather than rule of law. And what will happen when there is a rule of men? Obviously, there is a misuse of the power, authoritarianism, dictatorialship, and therefore it will infringe upon the rights, because he is not bound by the any rule book. So obviously, he is going to use the whims and fancies. As per his whims and fancies, he is going to he is going to rule in his own benefits. So this absence of rule of law is a threat to the security of individual, rights of individual, survival of individual. If there is no rule of law, so there will be an arbitrary rule. Arbitrary, you understand? Okay, there is no rule at all, and as per the whims and fancies, people might take any decision in their personal interest rather than in the interest of society. So it's very important to understand that rule of law, that when we say about the law, it means that rule is law based. Okay, it is not an arbitrary, it is not subjective. Okay, and this law is in the form of constitution. Okay, we are not talking about this as a parliament law, we are talking at a very macro level. Okay, this is in the form of constitution in the modern times, that all the modern countries or the modern state will have the written constitution. If at all it is not written constitution, there will be an conventions will be there, or some other way that the executive, legislature or judiciary will be abide by certain fundamental text of the land. What is the constitution? Constitution is a fundamental text of land. Constitution is a fundamental text of land which defines what is the organization of the state, and second most important point, what is the functions of different organs of the state, and the third, rather the most important point I would say, that is a limitation on each organ. Now this limitation on the each organ is placed by the fundamental law that is by the constitution, and therefore none of the organ of the state can go beyond the mandate that is being provided. So this is very important, that in this constitution it is also written, say for example, now here there will be a state and there will be people. Okay, when we say about the state, it is about the executive organ, legislative organ, and judiciary. Okay, and then there are people. So there is a contract. There is a contract between the people while establishing the state. So people have established the state by signing the contract, and this contract document is known as constitution. So it means that people have retained certain rights, certain freedoms from themselves. These are called as the rights. Rights are nothing but there are certain claims which are recognized by the society and as enforced by the law. Are you understanding? So in this regard, we see that if the rights are being violated, so there has to be a certain organ of the state in order to bring the or enforce the rights. So here comes the theory of fundamental rights. Fundamental rights are here. Okay, they are there to guarantee the existence of human beings. They are there to guarantee the survival of human being, and therefore they protect the people from the arbitrariness. They protect the people from the arbitrariness. So the nature of fundamental rights in part 3, as we understand, this puts the restrictions. Okay, many times question will be asked in the prelims, the nature of fundamental rights. Nature of fundamental rights are, they put the restriction on the authority of the state, and they make the state responsible. Responsible in a sense that a state can work only in a given mandate. Beyond that mandate, they cannot intervene into the life of individual. They cannot take away some of the fundamental rights. I hope the right and the philosophy of constitution is clear. Okay, so that's about the rule of law. So fundamental rights, okay, help in maintaining that particular rule of law. Now come to the types of rights. We'll see what are the types of rights. Yes, what are the different types of rights? Yes, what are the different types of rights? Natural rights, okay. Human rights. Yes. Natural rights, human rights. Human rights. Fundamental rights, yes, what else? Okay, constitutional. Constitutional, legal. What else? Okay, so this is one type of classification. Second type of classification is there is a political rights, civic rights, socio-economic rights, cultural rights, so on and so forth. Okay. So let me explain that what is this two classification. This classification is based upon one or two criteria, such as what is the basis of the rights. Okay, what is the basis, who provide you the rights. Here the two criteria is used, that is the source and the basis of the rights. Source and the basis of the rights. So say for example, what is a natural rights? Natural right is a right. Yes. Natural right is a right which is there, ordained by nature. Ordained by nature means what? You being a human being, even if the state is not there, at least the survival is guaranteed by the nature. So if the God has sent us on this earth, so obviously the existence of life, evolution of life, freedom, so some of the basic things which are ordained by nature are given to us. What is a source? It is a source is nature. Okay, and the basis is it's a survival, fundamental required for the survival. How about the human rights? Human rights, the rights to which individual are entitled to by virtue of merely being a human. So that's about the human rights. Again, these are very fundamental. How do you differentiate between natural and the human rights? Why we have the two different terms? And is there any correlation between the two? Human rights are also natural rights. Then what is the difference? Yes, you are right also. Animals also have natural rights. Okay. Within the human, what's the difference? Yes. Yes, somebody was saying something. They are derived. Okay. What else? Why there was a requirement of at all coming with the theory of human rights when the natural rights were already existing, if it is same as that of the natural rights? Yes, so natural rights are very vague in nature. There is a no textbook to enforce something which is ordained by the nature. So they are very vague in nature. So every single person is going to interpret as per his wish that this is my natural right. So we require a codification, okay, proper codification. Okay, these are the rights which are guaranteed to you. That's the first thing. From vagueness to there will be a more specificity to it. And second most important point is, in case of a nature, say for example, whatever the rights are available to you, if those rights are violated, there is nobody to check that your right has to be placed properly and the person who has violated your right should be punished. There was no mechanism. So there was a failed need. In fact, this theory has emerged after the Nuremberg trial. Okay, I hope everybody knows about it. Okay, that is a crime against humanity. When the Hitler has committed the atrocities against the Jews, okay, and then there was a lot of debate with respect to this violation of the human rights. And through the Nuremberg trial, the Nazi Germans were put on the trial through the crime against humanity. After that, okay, there is a evolution of the theory of the human rights that if something that is in the form of UDHR. What is UDHR? Universal Declaration of Human Rights. So Universal Declaration of Human Rights is nothing but the codification of what used to be understood as natural rights. But now they become more objective in nature. Objective in a sense that people know about it, that these are the rights, and if you violate these rights, obviously you will incur the punishment. Understood this part? What is the fundamental rights, and are they different from the human rights? And if yes, how? What is the fundamental rights? Yes? Are they different? Are they similar? How do you see that? Fundamental rights?
It's a subset of human rights where there is no any vagueness. It's
So,
specific.
okay. Yes, what specificity you see here? Yes, anyone? Why then we haven't used the term only the human rights? Basic needs, so what were here? What was here in case of human rights? So it's not an human rights, liberty, equality and all these things are not? Yes. See, the thing is that human right is a broader universal doctrine. Fundamental rights by nature, they are not at all different from the human rights. Okay. What we understand as a fundamental to the existence of human being. Why the word fundamental is coming? Fundamental to the existence of human being. That is, these are the bare minimum essential right that are required to be considered as a human, or to have a what you can say that the existence as well as a dignified life. Now why then again it is a difference? So if they are similar to human rights, but when we come to an India, okay, we have to grant, there has to be a state who will grant this rights to its citizen. So in fact, if you go by the generic name fundamental, it is not very different from the human. When we define the human right, the nature of human right remains the same, that these are the bare minimum essential right required for the existence of human being. Here also, these are the bare minimum rights required for the existence of human being. Only difference is this will be given in the part 3 of constitution, and it means that there will be an enforceability, very specific enforceability. So in Indian context, it gets a very technical meaning. Okay, in Indian context. So what human right is trying to achieve, the fundamental rights is also trying to achieve the same thing, but only in the specific context of India, and only with respect to those things that we have given in the part 3 of Indian constitution. Understood? And the another way of saying it, why the word fundamental, because these are guaranteed by the fundamental law of the land. And what is the fundamental law of the land? That is constitution. So the word fundamental has a two connotation, that is a fundamental for the existence of life, and it is guaranteed by the fundamental law. Fundamental, that is a basic law, that is a constitution. Constitutional right, what is mentioned in the constitution, it is depending upon the source. So within the constitutional rights we have fundamental rights and non-fundamental constitutional rights. Those rights which are not in the part 3 of Indian constitution. Legal rights, what is the legal rights? The rights which are guaranteed by legal statute. Okay, many of the rights may not be constitutional also. Okay, and they are the legal rights. Say for example, yes, what are the legal rights in India? One or two? Yes, right to property, and yes, yes, Food Security Act and Narega, MG Narega, so on and so forth. So all the whatever they established by the legal statute, okay, these are the legal rights. So this is based upon the source and the basis, whereas this is very simple, different aspect of the human life. Political aspect here, there will be right to vote, right to participate, etc. All political activities. Civic rights, what are the civic rights or civil rights? What is civil rights? Socio-economic, we know that equal wage for equal play and etc. etc. Cultural and religious rights. What is civic rights? Yes. So same thing, to have a civilized life. Okay, civilized life. That is the freedom which are given or the rights which are granted to an individual to have a civic life. Okay, so civic life mein what is freedom? Right to life, right to speech, right to freedom of association, etc. Article 19, if you can remember. So those are the aspects of the civic rights. I hope the point is clear. And these all rights, the nature is in order to put the limitation on the state that even if the state mandate is given to them, they should not enter into the domain of some of the rights which are required for the fundamental existence of human being. Why the hell at all we create the state from the anarchy to the state? Anarchy, because anarchy we were at least living there. We were living, but we want more than just an existence. We want more convenience. Therefore, we have created the state. So once we created the state, it means that the state has come for the happiness of human beings. It is not there to take the life. Life was already there. So some of the rights which are guaranteed, and that they put the restriction on the human beings. I hope point is clear. So what is the theory of rights? What is fundamental rights? What is rule of law? And what is constitutionalism? What is constitutionalism? Just in one line. What is constitutionalism? Is it the same as that of the rule of law? Yes, because rule of law establishes the rule by law. Okay, it is against the theory of rule of arbitrariness. Okay, it is against the theory of arbitrariness. There will not be an arbitrariness. So whatever the rule of law, it has to be established by constitution, and when we follow the constitution, it is called as constitutionalism. This is otherwise, you can remember, this is a theory called as limited government. Okay, this is theory of limited government. What is the word limited mean here? What is the word limited mean? Doctrine of limited government. This is called as doctrine of limited government. What is the limited? They are limited by the rights. Okay, they can only do what they are supposed to do, what is written in the constitution. Beyond that, they should not intervene into the rights of individual. So this is called as doctrine of limited government. This doctrine was given by John Locke, and therefore he is known as father of liberalism. Okay, he has ensured that the people, even if under the state, it does not mean that state is despot, state is a monstrous, state is everything. Okay, it means that people reserve some of the rights, and therefore it is known as the theory of limited government. Understood? So with this a basic introduction, now we move on to the specific rights in Indian Constitution, that is about the fundamental rights. Anybody has any doubt so far? Please do ask, otherwise we can move. Yes, any questions so far? No? Have you understood anything that I have discussed so far? Huh? ये पूरा मतलब यॉर्कर तो गया नहीं तो बाउंसर तो गया. Have you understood? Okay. So now let's move on to the fundamental rights. Again, we will see that some of the characters of fundamental rights first, and then we can move into the, okay, that is about the special provisions. So special features of fundamental rights. Special features of fundamental rights. So first and the foremost is these rights are justiciable, okay, which is different from, these are justiciable. This is different from preamble, this is different from directive principles of state policy or fundamental duties. Okay, justiciable. So why you call it justiciable? because if the fundamental rights are violated, then you can move to the, yes, Supreme Court or High Court directly. Okay, this is under Article 32 and this is under Article 226, and they will provide the writ, okay, writs through which they can enforce your rights. It's also very important to understand that justiciable means only when your right is violated. Only when your right is violated, then you can go to the Supreme Court and High Court. It means that somebody, you should objectively feel that my right is violated. You should provide certain substance and objective evidences. Then you go to the court and tell them my right is violated, and they will enforce it. What does it mean? It means that if nobody is violating your right, you cannot go to the court, I am not feeling my right are not there, and etc. Okay, so the violation of the right is a condition for enforcement. It means that they are already there. There is no special consideration that you don't feel like that there are right, and so therefore the positive intervention has to be there by the Supreme Court and High Court. Understood this part? So only when the violation, you can go to the Supreme Court or the High Court. That is a justiciable. Second aspect of right is, yes, what are the other features? They can be, yes, the rights are not absolute. Even if they are fundamental rights, they are not absolute. What does it mean they are not absolute? There are restrictions on the right. Even if rights are there, there are restrictions. There are restrictions on the rights. Now, what are these restrictions? Restriction can be seen in two ways. There are certain restrictions which are mentioned in the Constitution itself or within the Part 3 itself. Like say, for example, when we will discuss Article 19, we will see that they have mentioned the fundamental rights also, and there itself they have mentioned the, yes, restriction also. Second form of restriction can be Supreme Court and High Court through different judicial pronouncement, okay, or Parliament through the Constitution, constitutional amendments. Parliament through the constitutional amendments or different laws, and Supreme Court and High Court through the different verdicts. Okay, they have also gone for seeing the, okay, if at all any restriction can be put. Understood? So many a times the Parliament over a period of time has gone into like amending the some of the features of Constitution in order to restrict. In fact, one of the example is they have removed altogether also at a times. Okay, what is that time? That is right to property, okay, which was a right, but it was altogether removed. Then there are many of the rights which have been like amended over a period of time in order to put larger restrictions also. Okay, so restrictions, so they are not absolute, they are restricted. Third thing is, can they be amended? Can fundamental rights be amended or removed also? Can fundamental rights be amended? Yes, they can be amended. We will see in detail later on in Article 30, but at this point of time, just I'll say that fundamental rights can be altered, it can be modified, it can be changed, it can be repealed also. Okay, it can be changed, it can be repealed also. And this amendment, but it's not put as a simple law process. Okay, the Parliament, they have to go through the constitutional amendment. So constitutional amendment under Article 368, it means that they require the special majority. So it has not been kept that simple that if a particular government enjoys the majority and they can go for it. So constitutional amendment. Second restriction is, there is a restriction in the form of the procedure has been kept little difficult. Okay, so as to fundamental right, otherwise should not be amended. But yes, in special circumstances they can be. Second limitation is, if any of the fundamental rights hampering the basic structure of the Constitution, they cannot do so, and there will be, third, there will be a judicial review. Even if Parliament can go and amend, but again judiciary will see that if it is hampering the basic structure. If it is hampering the basic structure, they can reinstate back the fundamental rights in its original form. Okay, so what we can say that there is a balance, because you have to see the individual freedom and the larger social goal also. Okay, so some of the larger social goals, say for example, individual freedom, right to property was there, but then for the larger social goal, for the socialist goal, we have gone for the abolition. So sometimes the flexibility has been given in order to amend them, okay, to the constitution, to the parliament, but again, there is a caveat, that is a basic structure will not be violated, and if it is so, the judiciary will take the review and it will reinstate back. Okay, so the fundamental rights, there are restrictions, they can be amended. Fourth is fundamental rights can be suspended. Suspended means a temporary period. Okay, they can be suspended also. Okay, for a short period of time. This can happen, what is a suspension? This can happen during the emergency. Yes, this can happen during the emergency and this can in the national emergency. Which right do you know that which cannot be suspended at all? That's it. Article 21 and Article 22. Okay, in any circumstances, this right never be suspended. Article 21 and 22. 20 and 22, sorry. 20 and 21. Okay, this can never be suspended. First thing, with regard to suspension. Second thing, Article 19. There is something related to Article 19. Article 19 can be suspended in the national emergency, but only when the national, what are the national emergency provision, in which three cases national emergency can be applied? Yes, war, external aggression, and internal disturbances. No, now earlier it is called as internal disturbances, now it is called as on rebellion. So you can suspend Article 19 only in two cases. If the national emergency is through the war and external aggression. External aggression, you cannot suspend this. And this is an automatic suspension. Mind well, one of the feature of 19 is if the national emergency through the war and external aggression, then you need not, the president should not have to mention specifically your 19 got suspended. Okay, it will automatically get suspended, and the moment the national emergency get revoked, if it is on these two grounds, then those fundamental rights will be reinstated back. But in case of rest of the rights beyond 20 and 21, okay, the president has to mention in a special order that these are the rights which are going to be suspended for this number of period of time and for this part. So these number of rights for this particular part of India or whole part of India and for this long. Okay, so they will tell about which rights, they will tell about which part of India, and they will tell about that is till what time. Okay, so this will be not an automatic, and this is an automatic suspension. So what we are seeing is the fundamental rights, although they are justiciable, they are restricted also, they can be changed also, they can be suspended also. Okay, so these are some of the feature. Apart from that, there are certain other things like these fundamental rights. Most of fundamental rights are nature of restrictions imposed on state. Nature of restrictions imposed on state. This is what I have been telling for last half an hour, that is, they are the restrictions. They are the restrictions on the states. Whereas the directive principle of state policy, they are the guidelines. Okay, they are the guidelines. So they are telling that state, you please do this. And यहाँ पे state को कहा जा रहा है, you please do not do this. Okay, do not enter into. If the question will be like this, the fundamental rights, the nature, the fundamental rights are of restriction of the state, all the fundamental rights. The answer is not correct. This is what is, yesterday also I told you, please mind the extreme words in the statement. If the statement is saying that all the fundamental rights puts the restriction on the state, that statement is wrong. Okay, all fundamental rights do not put restriction. Some are negatively connoted. Negatively connoted, they put the restriction, but they are some are positive connotation. Positive connotation, like say for example, right to education. Is there any restriction or is there the sort of a guideline? That's a sort of a guideline. It's not a restriction on the state. So if all the fundamental rights are of restriction, that answer is wrong. Okay, you should not make it right, because many of the fundamental rights, in fact, why that only 21, within the 15, there are certain clauses, like 15.3 clause for the children and the women, then for the weaker section of the society, so on and so forth. So there are also positive guidelines also in order to, that is, establish the political democracy or the socio-economic democracy. Understood? So the word most should be kept in mind. Otherwise, they are the restrictions. Sixth is, fundamental rights are available, maximum rights are available to Indian citizen, but they can, some of the rights are available to foreigners also. Okay, some of the rights are available to foreigner also. At this point of time, I am not going to tell which are there and which are not there, because when we will see the details at the end of the conclusion of fundamental rights, we will take the list. We will be in position to appreciate it better then. Okay, so some rights are available exclusively to the citizen, whereas the some rights are available to the foreigners. अगर आपको चाहिए तो foreigners के लिए कौन-कौन से? Article 14. Okay, then Article 20, 21, 22, then Article, yes, that is it, I think. Okay, we will see that. Okay, some rights are available to the foreigners and some are to the citizens. Okay, so these are the some of the nature that you should keep in mind. And the last, in fact, we can say that this article, after Article 32, 33, 34 and 35, there are certain limitations. Basically the Article 31. So there are certain limitations in certain circumstances. Limitations in certain circumstances. Specific cases है, उसमें fundamental rights will not have an upper hand. Okay, these are related with Article 31 A, B, C, and then Article 33, 34 and 35. 35 is related with the law. We will see that. Okay, so these are the some of the limitations. We'll see later. I hope the points are clear. So what are the things? Also, you can say that some restriction imposed on the state, but at times there are restrictions also on the private member also. It is not that always the restrictions are only on the states. At some areas, there are restrictions on the private members. Say, for example, abolition of untouchability. It's not just the restriction on the state. It is a restriction of the other individuals of the society. Say, for example, article number 15, clause 2. What is 15? Yes, there should not be, state will not discriminate on the 5 grounds. That is a clause 1. And clause 2 is on a public places. Okay, so there should not be discrimination on the basis of 5 different criteria. So second clause, when we discuss about there should not be discrimination in public places like extracting the water and having an access to the shops and etc. That is a restriction on the individuals also, not just about the states. अगर ये point अभी नहीं समझ में आया तो when we will see the details, you can understand that. Okay, so that's a by and large the nature of fundamental rights. Many a times questions are also framed on different aspects, so you should be very particular about, okay, the specificity within it also. Okay. Yes, any questions so far? Otherwise, we can now move to the Article 12. Okay, before that, okay, Article 12 and 13 करके फिर then we can take the class of rights. Yes? हाँ. Basic structure. बेसिक स्ट्रक्चर हम आएंगे ना उसके ऊपर. ओके, केशवानंद भारती केस एंड आर्टिकल 13 में उसको डिटेल देखेंगे. यस, एनी अदर क्वेश्चन? एनी अदर? शैल आई प्रोसीड? Shall I proceed? Are you there in the class? Okay. So let's start with, see that first you can write the class of rights, different class and different types of rights within the fundamental rights. How many types? Yes, 7. 4. Yes. Types of fundamental rights or category of fundamental rights. There are 6. Okay, initially there were 7, but one has been removed. That is right to property. right to property has been no more of fundamental rights. So remaining are 6. Again, remember that this is a category. Okay, there are not total number. Total number might go higher. Okay, these are the 6 category of rights. So what is the first category? Right of equality. Right of equality. Okay, now the equality is established through which articles? Article 12 and 13 is different. 14 to 14, 15, 16, 17 and 18. Okay, so these are the right to equality. Second is right to freedom. Yes, this is article 19, 20, 21 and is there anything? Yes, 21A. Do not forget this. What is 21A? Yes. Third is right against the exploitation. Right against exploitation. This is article 23 and 24. Right against exploitation. Then fourth is, yes, what is the fourth? Yes, right to religion. Okay, something we have seen yesterday also, some of the aspect, that is a secularism and etc. That is from article number 25, 26, 27 and 28. And then finally fifth, cultural and educational rights. Cultural and educational rights. This is article, yes, 29 and 30. You should mug it up, okay? You should mug up these rights. And sixth is, yes, constitutional remedy. Right to constitutional remedy. In fact, this is what we were discussing about enforcement, that fundamental rights are justiciable. So that having this justiciability itself is also one of the fundamental rights. So in order to rest of the rights should be enforced. So right to remedy, article 32. Article 226 bhi aayega case mein? No, it will not come because this is a part 3 only. Okay, although you can go to the Supreme Court, but it is not a part of fundamental right. So right of constitutional remedy under the part 3, it is only about the article 32 with respect to the Supreme Court, okay, guarantor and the provider. So these are the 6 different categories of rights. Okay. Now, if you see this article is starting from 14, whereas the part 3 starts from 12, 13 and to 35. So what is this 12 and 13 we will discuss, because this is also a core part of it. Okay, although they themselves are not under the category of fundamental rights. These are something that whatever is being discussed part 3, so whatever the terms that are being used, okay, what are these terms and what is the relations regarding that, article 12 and 13 is there. Okay, so let's start with article 12. What is the article 12? Yes, definition of the state. So whenever we are saying that there should be restriction on the state should not do this, state should not do that. So to whom we are referring to? Okay, when we use the word state. So it is about the definition of state for the part 3. For part 3. In fact, for part 4, is there any different definition? It's the same definition, but which is repeated again, okay, in the different articles. That is article 36. Okay, so definition of the state. So when we say about the state, what does it includes? That has been defined. There are 4 things. Simple. That is at the central level. What will be there? That is a central executive and, yes, central executive and central legislature. Central legislature. That is parliament. Central executive and central legislature. So it means that the fundamental rights are not just against the law, they are also against the executive orders. Understood? So it's generally we tend to see that the law made by the parliament, but it can be also against the any kind of the executive order. Second is state executive and state legislature. State executive and state legislature. Then third is local bodies. Local bodies include the Panchayati Raj and municipalities and district boards, okay, etc. Corporations, okay, all those aspects, that is the local bodies. So local bodies, if violate, that's also come under. And fourth is, they call it others. Now others is also been specifically defined. Who are the others? Okay, who are the others? Some of the government bodies that have been formed by the law, okay, by the statute. Okay, say for example, National Human Rights Commission. Okay, so there was a National Human Rights Commission Act. So many of the bodies, okay, government bodies have been formed by the statute. So those bodies are also a part of state. So those bodies will be discriminatory. You can consider it as a violation by the state. That is the first. There are four things. That is a something body which has been formed by legal statute. Second, a body which is getting the fund by government. Okay, that is it is taking a substantial fund from the government. Third is any body which is carrying out the functions of state. Okay, delegated functions rahe honge unke. Okay, some functions have been delegated to certain bodies. So all such bodies also. So a body which is yes, established by the law or the statute. Some body which is getting the fund. Okay, somebody here, say for example, any institutes which is a private, but it is taking a substantial fund from the government. So obviously that body becomes the state. Okay, come under the definition. Functions of state. And the fourth one is, yes, body which may be controlled some or the other way by the state. Okay, just for the sake of understanding, I have written like this, but just broadly remember center, state, local, and rest of the bodies. Some other way there is a control of the state, some other way, central government or state government or so on and so forth. So any of such body is the part of the definition of Article 12. Okay, many a times there is a dispute with respect to different bodies, but we are not entering into that because that's a part of the mains class. Okay, and nobody is going to ask whether the BCI is what and this is what and that is what. Okay, so IPL is whether it is substantial, to aise koi nahi puchega. ठीक है? So remember this much only. Now let's move to the Article 13. Okay, Article 13. Again, very important part of the Indian Constitution. This part 3. Why it is important? What is Article 13? Broadly in one line. Yes, it is about the judicial review. Okay, broadly. Okay, so Article 13, agar broadly, although the word judicial review is mentioned in the Constitution or not? No, it has not been mentioned, but it is a very implicit. So it is about the judicial review. Judicial review. So first of all, we will just take in a brief 1 or 2 line what is judicial review, and then we will see that what are the clauses, so that you will get a broad idea about it, and then we can go by clause by clause. Yes, what is judicial review? How do you define the judicial review? How do you define the judicial review? See, some of the definition you should articulate well, because in the mains, some questions like this, judicial activism, judicial overreach, some kind of the questions come. So you should know a very proper definitions. Okay, like say for example the one we have discussed in case of rights. Everybody know what is right, but the point is, if you know proper a legal one-line definition, it makes some difference in fetching the marks. Okay, it shows that you know the very specific things regarding it, and it also helps in impressing the examiner also. Yes. How do you define the judicial review? What's the judicial review? Criticizing. ऐसे तो word use ही नहीं करना चाहिए. Okay. Is any organ? Samiksha. Okay, Samiksha. हाँ, Samiksha is fine. Okay. In the interest of nation, would you call this way? In the interest of nation, when the law is not when the law is passed, which is not in the interest of nation. Yes, yes. It has to be very specific that the law is not, yes, as per the provisions of constitution, or in this case, if it is in contravention with the fundamental rights. So, आगे क्या? हाँ, court to what? Strike it down to an extent of contravention. Yes, while mentioning you should, so that is what sometimes we make the mistakes. You are only focusing upon the law. It can be a law, it can be an executive order. So comprehensive definition should involve, okay, it should not miss the points. It's not just about the law. It can be also about the executive orders. So if you want to take the definition, you can take, it's the power of higher judiciary. Again, it's very important. Can subordinate court go for the judicial review? Does the subordinate court has a power? We generally say that it's the power of a court to review. Local body ने कुछ किया है पंचायत ने. It infringes upon your fundamental right. You have gone to some court. So, no, it's not a power. Okay, it's a power of, they call higher judiciary, and higher judiciary are Supreme Court. That's it. No, High Court and Supreme Court are called as higher judiciary, whereas the anything below the High Court, that is at the district and sub-district level, so this is a subordinate court. So it's the power of higher judiciary. It's the power of higher judiciary, in bracket High Court and Supreme Court, to check the constitutional validity of, law passed by center or state, to check the constitutional validity of law passed by center and state. Center matlab parliament and the state legislature, and the executive order passed, and executive orders passed by, again, center or state. Okay, full stop. To check the constitutional validity. Now again, if the court found something, if the court found the law or executive order, if the court found law or the executive order in contravention with the fundamental rights of part 3, comma, it will be termed null and void. It will be termed ultra vires or null and void to an extent of contravention. Contravention ko ya fir inconsistency ko. Okay. So whatever so let's understand that definition. It's the power of High Court and Supreme Court. So it can be a law or it can be an executive order. So say for example, this is a law, maybe the part of the law is not well. So only this much of law can be termed or be, yes, invalid, and the rest of the law will be there. If the whole half of the law, if the whole of the law, so depending upon, okay, how much it has violated. There are certain doctrines with regard to how much to violate and not, okay, how much to struck it down, we will see later. Okay, at this point of time, the judiciary is going to revise. So in fact, this is what it's not the right are being provided only for the name's sake. Okay, there is also a judicial review even before you go for the violation. That's the later. There is already a judiciary which is going to see the judicial review, and if it is violating the fundamental rights, it will struck it down. So this is again a very important aspect of that is a separation of power also. Yes?
So High Court can strike down a central law?
Yes. Yes, in India there is no federal system of courts. It's the integrated system of courts. Yes, it can. Okay, not only the central law in this case, otherwise all the ordinary laws and etc. everything. Okay, so this is a hierarchy. It has nothing to do with High Court is for the state laws and the Supreme Court is for the central laws. Okay, so that we will see as a part of a federalism. Whereas in case of America, it is like that, because in America, the courts, state courts are there for the adjudication of the state laws. Okay, we have the integrated system. Yes, let's come to the now provisions of the articles. Okay, broadly we have discussed what is judicial review. Now Article 13, there are three provisions, four provisions. First provision is, I'm not writing the text. Okay, that's not important for us. The first provision is related with the pre-constitutional laws. Okay, pre-constitutional provision is related with the pre-constitutional laws. It means that before the commencement of constitution, what is the date for commencement? Yes, 26 January 1950. And what is for the enactment? Yes, that is 26th of November. Okay, so before the commencement of this constitution, okay, there may be certain laws. Obviously, there are laws made by the 19, मतलब जो भी पहले के laws बनाए हुए हैं by the competent authority. So what about those laws? If those laws are in contravention with the part 3. So this has been discussed under 13 clause 1. So on the pre-constitutional laws, it does not mean that if you start the law, okay, if you start the law, immediately such law become null and void because now we have brought the new constitution. It is not like that. Okay, this is called as the ab initio. Ab initio means since inception. Okay, there is no contravention of such law ab initio. Matlab the moment we start the constitution, all laws are null and void. That's not the case. Okay, so there is no retrospective effect. Law will be there, and the law, the constitutional validity will be applied. Only that part of the law which is come in contravention with the part 3, that will be null and void. So whole law will not be strike it down. The other laws which has nothing to do with the part 3 violation will remain in force. Understood? So the application of judicial review for the pre-constitutional law is given in, yes, that is Article 13 clause 1. Understood? Second, now this is for the present. Generally what we understand judicial review for the 13 clause 2, generally we write this. This is because ये तो pre-constitutional हो गए, but after the commencement of constitution, Article 13 put restriction that state cannot make the law. They write this way, that is a state cannot make the law. State cannot make the law which is inconsistent with the part 3 of constitution, which is inconsistent with part 3 or fundamental rights of constitution. And if such laws are made, then there will be a judicial review and they will be struck down to an extent of inconsistency. Okay, first of all, you should not make it. And if you make it, then we are there. We will check the constitutional validity. We will see if it is a violation of the part 3. And if it is a violation of part 3, we will struck it down to an extent of inconsistency. I hope the point is clear. So this is for the present time, that any laws that has been made by the, yes, parliament or the state legislature. Understood this point? Okay, so this is a judicial review for the pre-constitutional. This is for the post or for the present time. Now what is the clause 3? क्लॉज 3 जैसे हमने स्टेट डिफाइन किया गया था, तो यहाँ पे हम बोल रहे कि लॉ विल बी स्ट्रक डाउन, लॉ विल बी स्ट्रक डाउन. सो दे हैव डिफाइंड कि व्हाट इज द लॉ. What is the law? So what is the law? Generally we understand law which is made by the parliament and the state, but apart from it also include ordinances. So if the question is asked whether the ordinances can be judicial review, yes, they can be. Then any kind of the orders, any notification, जैसे UPSC का notification है, if they are saying that कि मतलब any kind of the contravention of Article 3, okay, so you can go into the court if at all. Say for example, उन्होंने reservation की सीट ही नहीं दे दी, ठीक है? They have said that we are going for the meritocratic society out of the blue. We will be the revolutionary. So obviously that notification will also be considered. Okay, gazette notification, orders, even the customs and these practices which are enforced in the court, okay, which are enforced. So all such things. So in short, it means that government, whatever it does, okay, in the form of a law, in the form of an order, notification, etc., everything. So it does not mean only the law which is passed by parliament. So there can be an executive order also. there can be notification also, there can be gazette and etc etc. So anything that, so it's a quite comprehensively defined, but again there is a lot of debate here, and that is debate come in the form of 4. Okay, they have said that what is not included in this, एक चीज include नहीं है, and what is that which is not included? Yes, constitutional amendment is not a part of law defined under 13 clause 3. We will see that what is its implication. So in a simple sense, the clause 4, even if the law is defined in a very broader sense, still article 13 clause 4 says constitutional amendment will not be under the definition of law, mentioned under 13 clause C. ये 13 clause C वगैरह ऐसी चीज़ें important नहीं है, just आपको ये याद रखना है कि constitutional amendment do not come under this definition. The number is absolutely immaterial. Even if you don't remember, not at all going to make any difference. Get last 10 years question paper, not even once UPSC has asked subclause, not even once. Okay, so don't worry about these clauses. But yes, what is the implication and why it has came at the first place? That is very important. Constitutional amendment should not be the part of law. Why it has came at first instance, that we have to see, because we need to see that whether the constitution can be amended or not. Okay, fundamental rights can be amended or not, and if at all the fundamental rights can be amended, whether there can be judicial review for such constitutional amendment. Okay, understood? So we will see here what has been the history of it, but at this point of time just remember this much, and then we will come. Just remember, wait for a while, we will explain this. Okay, but remember this 4. Okay, and then we will go slowly and we'll reach to this point. In fact, somebody has asked about the basic structure and all that debate is included here. Okay, so let us move on to like 13 में ही हैं हम. There are certain doctrines which you should remember. Okay, one or twice UPSC have asked about it, and they are good to know doctrines. Okay, बहुत सारी doctrines नहीं है, 3-4 doctrines है which are applicable for the judicial review. So this will also give you, if there is a sort of confusion that which law should be struck down, how the judiciary goes about it, why don't struck down few of the things. So those answer can be given by some of the famous doctrines. Okay, so the doctrines, you can just put it, doctrines related with the article 13. Okay, yes, what are the doctrines you know? What are the different doctrines you know for the article 13? You don't know any single doctrine? Okay, so colorable is a very broad aspect. और बताइए, very basic doctrines. Doctrine of eclipse. Doctrine of eclipse. Then doctrine of severability. Doctrine of waiver. And the doctrine of basic structure. Basic structure. Okay, simple. There are, we are not going to go into the legality. Okay, one line for each one of this. Something we have already discussed, but let us do it once again. See what happens in case of eclipse. Yes, anybody know what is the doctrine of eclipse? See, yes. So again, not law. Okay, anyways, okay. See, the thing is that if there is a law, okay, now what is happening here is, if you have some fundamental right, now when we say that a law which is in contravention with the fundamental right, then such law will be struck down. If some part of the law is there, then only this much part is struck down. Now think of, now struck down मतलब उसको एकदम ऐसे निकाल के वो नहीं कर देते, फेंक नहीं देते, मतलब उसके कागज वागज तोड़ के, ठीक है. It is there in the statute. It is not in force. Okay, it is there. It becomes a dormant. It is not enforceable. It is remain there. Now, there can be a possibility where in future the parliamentarians might amend the fundamental rights, okay, or modify the fundamental rights, alter the fundamental rights. Now, in future, now at this point of time, this fundamental right has violated some portion of the law, but since now it has got modified, so this portion of the law again becomes, okay, come into force. Are you understanding? Because the very fundamental right, okay, this fundamental right was violated, violating this part of the law. But now let us see, it is FR dash, or FR has been removed completely. There's a right to property here. So in this case, this part of the law became once again active. That is called as the doctrine of eclipse. Eclipse इसलिए है कि ऐसे मून है, देखो आप ऐसे ऐसे जा रहा है, तो यहाँ पे eclipse हो गया. Are you understanding? Okay. So this has eclipsed the portion of the law, and then eclipse is getting removed. That is called as doctrine of eclipse. What does it mean? The law which has been struck down is not permanent striking down of the law, but it only get eclipsed. It only get eclipsed, and when the eclipse get removed, generally ये बहुत मतलब permanent eclipse रहता है, मतलब ग्रहण जो है permanent ही रहता है, but sometimes it happens as it has happened in case of the fundamental rights of right to property. तो एक example, मतलब crude example है कि एक आधा law होगा, law के ऊपर right to property की वजह से ये struck down हो गया. Now right to property is no more a fundamental right. So obviously that part becomes again active. I hope idea is clear to you. Okay, so any kind of the law when it becomes struck down, it do not get vanished completely. It only gets dormant. It only get dormants, and whenever such influence, whenever such mangal gets removed, okay, it becomes active. That's about the doctrine of eclipse. Now, doctrine of severability. The word severability is a separation. The literal meaning of it is a separation. Literal meaning of it is a separation. So separation mein again the same thing. When the law will be struck it down, they will separate the bad part from the good part. Bad part matlab the one which is getting violated by the fundamental rights. So they will remove this part and they will maintain the good part. So that is called as a doctrine of severability. That severability, we will separate the good part from the bad part. We will struck down the bad part, but we will maintain. This is because the law has been made after a lot of discussion, deliberation, and there is a reason why the law has came at the first place. So Supreme Court tries to, this is a liberal interpretation. Liberal interpretation, they try to save the law for getting stricken down completely. But there are certain conditions. Conditions क्या है? मतलब ये आपके लिए important नहीं है, but it's a very common sense logic कि after removing this bad part, if this becomes so thin that there is no relevance of it, so in such cases they will strike it down. Okay? If bad part is the core part of the law, जिसके लिए law बनाया गया था, तो इसमें तो कोई बचा ही नहीं है, then again it will thrash. But if this part is removed and this can function independently also as a good law, then only they can maintain it. तो ऐसा नहीं है कि मतलब एक ही लाइन बच रही है, उसको भी बचा दिया, मतलब कोई मीनिंग ही नहीं है, ठीक है? That's not the thing. So they will maintain that part of thing. That is called as the doctrine of severability. Understood? See, the doctrine of eclipse initially was only applied in case of pre-constitutional law earlier, but now it has been for the both pre-constitutional as well as post-constitutional law. Doctrine of waiver. What is the word waiver mean? Yes, give up. So what does it mean? क्या होता है यहाँ पे? Waive off the loan. Farmer's loan is waived off. Yes. Who is waiving? What is waiving? Yes, to give up the rights. So what is its implication? Can you explain? Yes, you are right. See, the thing is that people or me as a person will say that for my country I give up my right, fundamental right. तो एक पार्ट 3 के मैं एक लिस्ट ऑफ राइट्स दे दूंगा कोर्ट को या फिर गवर्नमेंट को Okay, I give up my rights, so you make all the laws possible. Matlab, take away my fundamental rights. So they can make any law. Are you understanding? The people themselves are waiving off their rights, so that there will not be a problem for the parliament or the executive to make the laws on the fundamental rights, because I have waived off my right. This does not happen in India. Okay, this happens only in America, so therefore it is not applicable here. But yes, doctrine of waiver has an implication on making the laws, because it creates a lot of space for the parliamentarians and executives to come up into that space. तो वो space उनको मिल जाती है. इंडिया में क्या होगा, वो forcibly फिर gun bullets के ऊपर waiver चालू हो जाएगा. ठीक है, तो that is not there in case of India, remember. Okay, and the last, that is doctrine of basic structure. Doctrine of basic structure, we have to take evolution of doctrine of basic structure. So just write the doctrine of basic structure. Yes, what is the doctrine of basic structure and why it has came into existence? Okay, let's broadly understand this way. That is, there is a parliament or legislature and executive here, because in case of India, executive are drawn from the, yes, legislature only, and there is a judiciary. There is a judiciary. Okay. Now, judiciary, the role of the judiciary is to enforce and protect and guarantee the fundamental rights. Now, more they are protecting, less is the space available for the parliamentarians to make the laws. Now, what is happening once there is a commencement of constitution has started, okay, there are various policies and the laws that are required to be, yes, formed in order to give the meaning to the directive principle of state policy, and etc., in order for the functioning of the governance. But whenever they are doing so, sometimes they are entering into the field of fundamental rights, which is not liked by the judiciary, and judiciary is telling that you should mind your space. Okay, you should not enter into this space. So what they are doing, they are trying to amend the fundamental rights completely altogether, कि हम नया right लेके आएंगे, या फिर हम modify करेंगे, या फिर हम completely remove ही कर देंगे, so that you will not shout at us that we have, yes, that we have violated some fundamental rights. If there is no right only, so what is violation of? तो वो एक debate tussle चलता रहा. तो इससे doctrine आई है basic structure. So first time क्या हुआ था? Okay, there is a first case called as Shankari Prasad case. Shankari Prasad. This debate is very important, because otherwise this debate is at 3 levels at least. Judicial review में ये debate आता है, fundamental rights and DPSP के जो aspects है उसमें debate आता है. What is the where the fundamental rights are supreme or directive principles are supreme, उसमें debate आता है. This debate comes in constitutional power. Okay, that is a constitutional amendment power of parliament, whether the parliament can amend anything and everything, or are there restrictions on the parliament? Is the parliament equal to constitutional assembly, okay, which has given us the constitution? Are they so powerful that they can bring a new constitution for us or modify? So all these debates. So one debate is fundamental rights and directive principle. Second debate is constitutional amendability. Okay, and third is that is a tussle between the two. So what happened in case of Shankari Prasad case? Yes, in case of a Shankari Prasad case, when now this is why we are discussing under 13. Please remember these two important things. Article 13 clause 3. क्या था Article 13 clause 3? That is a law. Okay, that is, these are the sort of the laws. Okay, 4 was not there initially. We will discuss only this. So laws which are there, there will be a constitutional, that is, Supreme Court will see whether the law is in consonance with the constitution or not. Shankari Prasad case में ये हुआ कि Supreme Court, this Supreme Court has said initially, Supreme Court has said that law under the definition of this, law which are under the definition of 13 clause 3, that is constitutional laws are not a part of it. Constitutional amendments are not part of this law. it means that constitutional amendment is a very extraordinary law, and we will not make a judicial review of it under 13. So, what does it mean? It means that Parliament has got a lot of right here. समझ में आ रहा है नहीं आ रहा है? Everybody is understanding? The court is saying the law under 13 clause 3 does not constitute constitutional right. It is an extraordinary law, and therefore we will not make judicial review of it. It means that fundamental rights can be taken away by the constitutional amendment. So this was the original position of Supreme Court. So obviously the parliamentarians were very happy, and they have gone down in making the constitutional amendments. They have gone into the making the changes. Matlab they got in power. So here the Supreme Court has taken the stand that fundamental rights can be amended, and such amendments are not part of 13. Therefore there will not be a judicial review. So ball is gone into the court of parliamentarians and the, yes, that is executives. Now second thing has happened, that is after Shankari Prasad case, the Supreme Court has changed its stand in case of Golaknath case. Golaknath case. Now in Golaknath case, it has reversed its earlier order. They say that no, fundamental rights cannot be amended. Cannot be constitutional amendment. CA is a constitutional amendment. Fundamental rights cannot be amended, and they are transcendental and immutable. Okay, you cannot, transcendental matlab very, very sacred. You cannot challenge fundamental rights. Okay, they are very sacred, they are very pious, they are immutable. Now this is something what they have said here, they are mutable. And they have also mentioned that constitutional amendment is a part of law under 13. अगर आपने अगर ऐसे मतलब transcendental नहीं माना और आपने law बना दिया, तो that law will be a part of judicial review also. Are you understanding? It's a completely, yes, opposite of what was there in case of Shankari Prasad. Okay, that is also called as doctrine of prospective ruling. कि पहले था जो भी था ठीक है, but now this is the new position. So prospective means from here onward this is the position. So here onward this is a position that you cannot change the fundamental rights, and if you are changing it, we will make a judicial review. Now this is the time where now they were not happy with it, and they have reacted to it. They have reacted through 24th Constitutional Amendment Act. They have reacted through 24th Constitutional Amendment Act. Okay, and what they have come up with here, 24th Constitutional Amendment Act, that fundamental rights can be amended. Fundamental rights can be amended, and here they have added 13(4). 13(4) किस लिए ऐड किया गया? I hope now you are understanding. In 13(4) में लिखा गया, constitutional amendment are not category of laws. Have you understood? Okay, constitutional amendment are not category of law. तो यहाँ पे लिखा गया कि constitutional amendment will not come under the law. What does it mean? Implication क्या है? You cannot take a judicial review. You cannot take a judicial review. So we can make changes in the fundamental rights, and also it is not your authority, okay, that to see to it that we have changed anything. Understood? Now here again the Supreme Court is going to react to it. Okay, Supreme Court is going to react to it because judicial review itself has been taken away. But remember, there is something they have accepted. They have accepted 13(4). That's why in today's statute you will find that 13(4) में जो law है उसमें constitutional amendment नहीं है. They have said that okay, you have made the constitutional amendment, we accept it. Constitutional amendment will not be a part of law for the definition of 13. It means that you can amend the fundamental rights. Fundamental rights can be amended, but okay, they have come up with the new doctrine, that is the doctrine of basic structure, that you can amend the fundamental rights, but you cannot take away something we are calling it as basic structure. And they are not defining it also. They are saying that we will see, you make the law, you amend the law, and then we will see that whether such law is violating the basic structure or not. And slowly over with the evolution, different case by case, we will add what is the basic structure. Okay, and it is quite possible many of the fundamental rights can be a part of basic structure. So even if they are amending it, the Supreme Court reserves the power of judicial adjudication and reviewing it to see that whether the basic structure is a part or not. Understood this? अब इसके बाद तो ये बेसिक स्ट्रक्चर तो काफी वेग और वो हो गया, मतलब इसका है कि procedurally they have accepted, procedurally they have said that okay, you can make the laws, but substantively they have reserved the right for themselves in something calling a vague term called as basic structure. Are you understanding what is the implication? Even if somebody will make the law, you will again strike it down calling it basic structure. Okay, this was the time obviously Keshwananda Bharati case कब था? Yes, 1973. So Iron Lady of India, she was not happy with it. Okay, so Mrs. Indira Gandhi obviously come up with the 42nd Constitutional Amendment Act. Okay, which was a very, you can say that unparalleled Constitutional Amendment Act. Now we are seeing most important part in this case. यहाँ पे उन्होंने 2 clauses add कर दिए 368 में Constitutional Amendment में. That is clause 4 and 5. Clause is not important. What is written is more important. एक में उन्होंने लिखा गया कि Constitutional Amendment को judicial review, no court can challenge, no court in India can challenge the constitutional amendment for any reason. Forget about the fundamental rights. Okay, no court can challenge the constitutional amendment for any reason. It means that they have completely taken, yes, that is a judicial review away from it. Are you understanding? So any constitutional amendment cannot be challenged at all. And second, they have added Parliament can amend anything in the constitution. Okay, both में any है. We can amend anything and no court in India can challenge it at all. Not only High Court, not Supreme Court, no court, and not only for the reason of this fundamental rights, but otherwise too, you cannot challenge. Okay, so for full power to the Parliament and zero power to the judicial review. This has been struck down. Okay, obviously this has been struck down by the Minerva Mill case. Minerva Mill case, that is in 1980, and Supreme Court has said that 38, 4 and 5 are rubbish. Okay, there is no separation of power. There is nothing. Matlab, it is getting fused. It is completely getting fused. So it has been struck down. So in present time, as we speak, what is the position that this constitutional amendment word does not or will not be a part of 13.4, but so it means that the Parliament can go for the amendment of the Constitution or amendment of the fundamental rights, but Supreme Court will see it through the basic structure doctrine. So that's the position. I hope points are clear. Okay, नहीं है तो बार-बार revise करना पड़ेगा, but that's the how the basic structure doctrine has emerged. Okay, so the position has been changed a lot of times. Okay, so let me sum up last position क्या है एक line में. If this evolution is not, if you haven't understood, at least remember the last, what has been the conclusion of this. Conclusion of this is simple, that is 13 clause 4, okay, would say that constitutional amendment word, okay, will not be a part of law, definition of law under 13 clause 3. Okay, so constitutional amendment does not come in the category for the part 3. It means that, okay, through the constitutional amendment, you can change the fundamental rights. Fundamental rights can be changed or altered, but there will be judicial review, and judicial review on the basis of basic structure doctrine. So this is what the position we have taken when we were discussing about what are the special feature of fundamental right. So one of the special feature is that is fundamental rights can be amended. Fundamental rights can be amended, but to an extent if they are not violating the basic structure. So the middle position has been achieved, that fundamental rights you can amend, but not it can touch the basic structure. So that's the balance is there after the Keshwananda Bharati. Again, when the Keshwananda Bharati was there, it will be a prospective ruling. Okay, after the date of this particular rule, and that has been the 13.4. So I hope the points are clear. So what are the things within the fundamental rights and this thing? So this is about the basic, even before the starting of the proper fundamental rights. This philosophy and this debate you will always find. If you understand this debate, it will be very easy for you to write the answers of the mains also, because this is the basis. Most of the times is the fundamental rights which come in the contravention, and therefore there are many debates happen. So if you know this, you can articulate answers properly in case of mains as well. Okay. Now let's come to the first article, that is a right to equality. Yes, if you have any questions so far, please ask. Otherwise, we can move. Are you following me? Yes, are you following me? Everybody? Okay. Yes, any question? Yes.
Sir, is there any writ required for judicial review? The Supreme Court or High Court can direct?
No, it is required. It is required, yes.
They cannot take no.
Yes, they cannot. Generally, they have to, somebody should approach to the court in stating that there is a certain problem and contravention of some other matter has happened. Okay? Yes. Let's come to now the first article. That is article of establishing the right to equality. First category of rights. Right to equality. Right to equality. So right to equality, there are how many rights within that? 5. Okay, there are 5 rights. What is Article 14? There's 15, 16, 17 and 18. Okay, right to equality, there are 5 articles. Yes? Any constitutional amendment?
From the earlier times, like 1 to 10, 1 to 20, are there, can be judicially reviewed?
Yes, they are. They are. Here we are talking just about the fundamental rights. Judicial review provisions, there are so many provisions. This provision is particularly related with fundamental rights. I'll tell you. No, prospective only for the fundamental rights. Not for complete. See, judicial review can be done on the basis of 3-4 things. One is about, yes, fundamental rights that we have seen. Second is with respect to the competency, that is article or separation of power in a simple way. Division of power. What is division of power? Yes, that is a center, state and concurrent list. So if the state is making the law on the central subject, then there will be certainly a judicial review. Here there is no violation of fundamental rights, but the court will say that it is beyond your competency. It has nothing to do with fundamental rights, but you are going beyond the competency. So obviously there will be a judicial review. Then third is, yes, broadly basic structure. Basic structure is not just about fundamental rights. There are so many things within the constitution which involves the basic structure. So they will say that, say for example, secularism, socialism and some other federal aspects. Say now in this case, Uttarakhand case, just we are saying, okay, it has nothing to do with the practical aspect what is happening. So if you have applied 356, okay, and it does not stand the test of the constitutional validity, the Supreme Court might say that it is a violation of the basic structure, because federal features of the basic structure, you are becoming an unitary completely. You are becoming despot. So in fact, yesterday they have said something like it is cutting the root of the democracy. So something like they say, so it has nothing to do again fundamental rights. So there is a judicial review on the basis of a basic structure, on the basis of competency, on the basis of fundamental rights, and fourth broadly as a constitutional validity. Okay, constitutional validity, not necessarily only the fundamental rights. It can be any kind of constitutional validity. I hope points is clear now. Okay. In fact, this is a very core part. That is a basic structure. Through the basic structure, in fact, Supreme Court has extended its power, and they have not even defined it. Okay. Over a period of time, they are adding more and more points to it, and they are saying that we can go for the judicial review. One of the example is they have Parliament has gone for something called as ninth schedule. What is ninth schedule? No, not Panchayati Raj. Yes, laws are saved from judicial review. Laws are saved from judicial review. It's like a sack. Okay, that sack will never be under the scanner of judiciary. So if you feel that judiciary will struck it down, so you make a law, bad law, and put that bad law into that particular sack of Schedule 9. So Supreme Court cannot do anything. Initially, Supreme Court are saying that we will not do anything till that extent it is not violating the basic structure. Okay? And what is basic structure? We will see it. And therefore, that sack is no more that black sack. We can go and say that this is a violation of basic structure. Okay, so even the ninth schedule is not immune now completely from, okay, there is a doctrine of basic structure. Yes, 1973 onwards. Yes, that is a prospective. 1973 onwards only, because in fact one of the basic thing is there is no retrospective effect. Okay, so that's also a sort of injustice. The law is not there and you are then again going for the retrospective implication. Generally, retrospective is given in case of civilian matter, not in case of a criminal or very sensitive matters. Yes, I hope points is clear. Okay. Because there were certain laws, we have to see 31B एक देखने वाले हैं आगे. Okay, so it's better when we'll take that. But simple reason is there are certain socialistic principles which you required to implement. तो हर एक जो भी आप implement कर रहे हो, it is getting challenged as a contravention of fundamental rights. So therefore there was felt need. ठीक है? अरे why to see, the thing is that the rule will be simple. Rule will be simple. There will be only one rule, that whether it will stand the test of constitutional validity. A simple rule. So NJAC was there. So they have found, because of the composition of NJAC and whatever it is, they thought it is infringing upon the autonomy of judiciary. Okay. If we go by the collegium system, there will be a more autonomy to it, and through this it is not. So on that basis, and they say that this separation of power and autonomy of judiciary is a basic structure. So the separation of power will get hampered. So that's the reason. Okay. Yes, now let's come to this Article 14, 15, 16, 17 and 18. Article 14, what is Article 14? Equality before law and equal protection of law. Equality before law and equal protection of law. What is Article 15? Yes, state will not discriminate. State will not discriminate on the basis of 5 criteria. What are the 5 criteria? Yes, race, religion, caste, then sex and place of birth. 5 criteria. State will not discriminate, okay, people, obviously those lines are there, on the basis of 5 criteria. What is 16? Equality of opportunity in case of public employment, not in case of a private. Okay, public employment. So in case of a public employment, you will not be denied, okay, right of opportunity or equality of opportunity, again based upon criteria. You will not be denied based upon 7 criteria here. What are the 7 criteria? All these 5 plus 2. दो कौन से हैं? Descent and residence. Descent and residence. These 7 criteria. Only these criteria. This is just we are reading the titles. We will come again. अगर ये just एक overview चाहिए कि equality कैसे establish हो रही है. 17 is about, yes, abolition of untouchability. Untouchability. And 18 is about, yes, abolition of titles. See, all these things collectively establish the equality, the goals of egalitarian society, equality, okay? So these are the goals. Now, why we require again 4 laws, that's also important, because if we consider broadly a society, okay? So one is, this is creating a formal notion. एक formally बता दे रहे हम कि state is not going to discriminate, all are equal in the front of law, okay, etc., etc. But this is a very formal notion, and if we see there are certain rich, certain poor, and so on and so forth. So if we will not make certain other provisions, specific provisions, this will not have any significance. Therefore, we have to make a provision. Okay, let's come first to the 17 and 18. There are few people who are so-called, matlab, there has been a discriminatory practice of untouchability. So even if you are saying that all are equal, there is already existing reality in the society. Some are untouchable. Some are enjoying lot of titles, okay, or there is obviously whenever you give the titles, it create a elitism in the society. So तुम्हें elitism भी खत्म करना पड़ेगा equality के लिए, तुम्हें untouchability खत्म करनी पड़ेगी. You have to formally also declare, and plus then you have to say that in other cases also state is not going to discriminate on certain specific criterias in general and in specific to the public employment. Public employment is for the economic justice, and this is for the any kind of the social justice that is required. I hope the point is clear. So sum total of it, you should also like mechanically you should not remember. Okay, you should know the purpose of it, so that this will also be useful for your essay writing and socio-economic जो issues आते हैं. Otherwise also it's very important. So this all try to establishes the goal of equality and the egalitarian society. So we will see that one by one what are the issues within it and what are the different points regarding the establishment of this. Okay, so the first is, write this, that is the equality before law and equal protection of law. Equality before law and equal protection of law. Now this is a notion of formal equality. This one more thing, this is available to the foreigners also, and this is available to the citizens also. Okay, equality before law and equal protection of law. There are two connotations here. Okay, before going into two connotations, simply to put it, all are equal in the eyes of, all are equal in eyes of law. So that's the, because that two terms and their interpretation, okay, both are saying the same thing in two different ways. Okay, same wine is kept in two different bottles. One is in the British bottle and one is in the American bottle. Okay, one is थोड़ा सा negative, one is थोड़ा सा positive. एक kick देता है, एक मतलब total वो कर देता है समझो. Okay, but the same thing is there. Okay, same wine is there. So what they want to say is not different in two. Ultimately, they want to say that all are equal. All are equal in the eyes of law, and state is not going to discriminate. State is not going to discriminate between the rich and the poor. They are not going to discriminate between the different genders, etc. Bracket में LGBTs, obviously that is one of the thing. Okay, so these are the aspects that they are trying to establish. Okay, now let us understand the word का क्या meaning है. Okay, that is equality before law and equal protection of law. कौन सा पॉजिटिव है और कौन सा नेगेटिव है? Yes, this is called as negative concept. Negative concept मतलब it has nothing to do with the, this is negative मतलब खराब concept, ऐसे नहीं है वो. Negative is negative connotation. While saying it, we are saying it negatively. How we are saying negatively? That there will be no privileges. Okay, there will be no privileges to any specific person. So ऐसा नहीं है कि हाँ ये शाह है इसलिए कोई मतलब इनके लिए कोई रूल नहीं रहेगा. ठीक है, ऐसे कोई नहीं होगा. ओके, विजय माल्या कोई नहीं है, या फिर so on and so forth. All are equal. Okay, so but that is very formal in nation. No privileges. गरीबों के लिए भी रहेगा. No discrimination. So no करके हम बोल के establish कर रहे equality. There will be no one above the law. No one above the law. This is in fact trying to establish the rule of law. Now you go back to the first, I have started with the notion of rule of law. What is the notion of rule of law? That there will no arbitrary, okay, rule. Matlab no one is above the law. So whatever the law, even the highest constitutional post, that is a president, will be also be, okay, liable to the law. Okay, understanding? There are certain immunities, obviously, we will discuss that later, what are exceptions. So since we are saying no, 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 that's why it is negative concept. This has been borrowed from, yes, Britain. Okay, this has been borrowed from the Britain. In a way, they want to say that all are equal. Okay, here in this case, this is called as the positive concept. This is called as positive concept, and this is borrowed from US. While saying, we will say now positively that state will ensure, यहाँ पे क्या बोल रहा है? State will not discriminate. Okay, negatively बोल रहा है. State will not discriminate. State will ensure that all will be equal in the eyes of law. Positive connotation. Or in other words, a famous line is also used. Similarly placed people. Okay, people in similar circumstances will be treated similarly. Okay, equally. So positively बोल रहे हैं. We are not saying there is no discrimination. We are saying that those who are in the similar circumstances will be treated similarly. So that's the positive way of saying it. Positive, negative, याद रखना है रखो नहीं. Simple as all are equal in the eyes of law. This is applicable for the citizen also. This is applicable for the, yes, foreigners also. So this is the universal in nature. It means that even if the foreigner is there, we will not discriminate. That is, we haven't discriminated even the kasab. Yes, that's in, no, इसमें हंसने का नहीं है. We should take a pride in a due process of law. We have followed the due process of law, that this will be followed. This will be followed even if it is a foreigner. Okay, so that's the point here. But there are certain exceptions also given. Certain exceptions. Yes, there are certain exceptions. In fact, this details of exceptions we will see in the respective chapter. But here there is a president and governor. Yes, president and governor. पहले इंडिया का देख लेते हैं, ठीक है? President and governor, diplomats आप इंडियन फॉरेन सर्विस में जाना है क्या पहले? मतलब इम्यूनिटी, देवयानी खोबरा गोड़े एंड दिस थिंग. ओके, यस. सेकंड कौन है इंडिया के अंदर? अरे हाँ, वाइस प्रेसिडेंट, गवर्नर. और MPs and MLAs. MPs and MLAs का क्या है? Whatever they say on the floor of the house and some of the immunities which are there, that there will not be during the session. Okay, during the session there will not be arrest, or there is a conditional arrest. You have to inform them, or you have to inform the speaker, etc. We will see that what are the immunities, because we will not complicate this topic. Just remember that there are certain conditions and privileges and the immunities which are given to the MPs and MLAs, president and governor. And third is, yes, for diplomats and so on and so forth. Okay, diplomats, that is a foreign, yes, IFS officer for the diplomats, or UNO, United Nations organization, etc. Okay, so there is a immunity provided to them. In fact, this is conditioned upon international convention that is called as Vienna Convention, if you know about it. Okay, Vienna Convention. Okay, that is called as a diplomatic immunity. Diplomatic immunity. The case of Devyani Khobragode, okay, if you remember, or in various cases, you can see that the diplomats are immune from the prosecution. Okay, but yes, it is for the parent country of that particular person. Sometimes they can waive off the immunities also. Okay, एकदम ही देश का नाम बर्बाद कर दिया, तो उसको क्या तो मतलब इम्यूनिटी देंगे हम. ओके, हमारा नाम बर्बाद हो जाएगा, इसलिए एक को बर्बाद ही होने दो. ठीक है. सो अ पेरेंट कंट्री कैन वेव ऑफ, बट ये इंपॉर्टेंट नहीं है यहाँ पे. व्हाई डिप्लोमेटिक इम्यूनिटी हैज टू बी देयर? व्हाई डिप्लोमेटिक इम्यूनिटी हैज टू बी देयर? व्हाट इज द रैशनली बिहाइंड इट? आर दे नॉट अ ह्यूमन बीइंग? दे आल्सो कमिट द क्राइम एक्सेट्रा. गेस्ट है इसलिए. अच्छा, क्या है वो हिंदी में स्लोगन? अतिथि देवो भव. ठीक है, अतिथि देवो भव ऐसे है कि वो इटालियन मरीन्स ने किस लिए मारा है वो समझ में नहीं आ रहा है. वो बोल रहे हैं कि यार हमें दिखाई नहीं दिया दूर से, टेररिस्ट से करके मारा, तो ये अतिथि देवो भव. मतलब काफी डिफिकल्ट है. So what? So they are liable to crime. Is the license given to them because they represent the other country? There has to be a uniformity. Every domestic law is a different law. Immunity है, इसका मतलब ये नहीं रहता है कि आप किसी कंट्री में जाके डिप्लोमेट बन के कुछ करो और कहीं पे भी कुछ नहीं होगा. Obviously it is not there. इंटरनेशनल कोड ऑफ आर्बिट्रेशन होगा या फिर यहाँ पे बुला के आपको सजा दी जाएगी. जिस कंट्री के आप हो वहाँ पे बदनाम किया जाएगा, रादर देन इट इज ऑलवेज गुड कि दूसरे कंट्री में कोई नहीं जानता है. बट ऐसे नहीं है. ओके, दीज आर द डोमेस्टिक लॉज एंड देयर आर सो मेनी प्रॉब्लम्स. So there has to be a certain, these are the things of courtesiness in international politics. Okay, as a part of a courtesiness, we go for it. They enjoy the immunity and they can carry out the diplomatic missions and their functions without fear and favor. Okay, otherwise there will be a lot of trouble that can be there for the diplomat. So these are the standards which are used in international politics. Anyways, so this is just an exception in corner. That's not important. Equality before law and equal protection of law. Okay, nothing in this article, because this is a very formal article. Okay, it's a very formal article. It is not trying to establish very substantive, because substance will come after we will take into account various social inequalities in the society, and then we will take the steps in order to bridge those gaps, in order to create the egalitarian society. Okay? This is a formal notion. Now let's come to Article 15. Article 15 and 16, perhaps the most complicated fundamental rights and most important one also. Okay, most debated, most controversial, most important also rather. Article 15. What is Article 15? Yes? अभी तो बताया था. State will not discriminate. State will not discriminate. State will not discriminate any person, any citizen, और company भी रहता है यहाँ पे. Okay, so person on the basis of 5 criterias. State will not. So we will go clause by clause because there are some details. 5 criterias. Yes, what are the criterias? Religion, race, caste, sex, and place of birth. Here the word is state will not discriminate any citizen only on the basis of, either of this criteria. Only on basis of any of this criteria. अरे 5 कहाँ हो गए? 5 हो गए? Okay, 4 and 5. We will see that what is the only word later on. Okay. Second clause क्या है? There will not be discrimination. Okay, I will not write same 5 criterias, but except for the fact that यहाँ पे एक general है. Clause 1 is a very general. Clause 2 is a very specific. 5 criterias in special cases. I am not writing special cases. And special cases क्या है ये? That is access to the shop. Okay, drawing the water from the well, going into the parks. Okay, जो भी public places है. Okay, I am giving the generic word यहाँ पे. That is a public places. So whatever the public places are there, there should not be any discrimination. Now, before going into 3 and 4 and 5, we will see the difference between the two. Okay, इसमें और इसमें difference क्या है? Okay, yes. So this is the against the state. Okay, that state should not discriminate. So it is putting a restriction only on the state, whereas this put restriction state plus private individual or public or society. Private individual. That is the scope. Okay, scope is here. We can say that it is extended. So if you are carrying out discriminatory practices at public places on the basis of 5 criteria, then that's the violation. Okay, so private person also can be, okay, that is charged under the violation. Second difference between first and second is, that is first is it is extended to the state and private individual. Second is this is very general sort of discrimination. मतलब इसका scope wise ये scope बहुत बड़ा है. किस किस के लिए? मतलब a variety of the ways state can discriminate. Here only it is related with the public place. Are you understanding? The target of the population उस हिसाब से इसका scope ज़्यादा है, because individuals are also important, but on the basis of which subjects, मतलब which sort of issue is to be discussed, ये बहुत general issue है. कोई भी issue आ सकता है जहाँ पे state ने discriminate किया हो. Say for example, in case of appointment, in case of contract allocation, in case of any other criteria that can be possible, and here it's a very specific criteria. Understood? So these are the negatively worded again. 15 clause 1 and clause 2 put a restriction either on the state or on the private individuals in order to not to discriminate people. Therefore, the equality can be established because you are not discriminating. But this is again not sufficient because there are state should also take positive intervention. Not only just remain silent, okay? They should take the positive discrimination. Generally, we call such discrimination as protective discrimination, positive discrimination, preferential treatment, affirmative action. Okay, are you understanding? So this is a sort of a negative restraint, but there are certain positive things also. So Article 3, Article 4, and Article 5. Okay, so this is in fact sort of creating the positive discrimination. Again, positive discrimination to remove the inequalities. Article 3 में क्या positive discrimination है? State will make the provisions in the interest of women and children. Women plus children. Okay, so they can go for making the laws. Now here you can simply see, ऊपर लिखा है कि there will not be discrimination on the basis of sex. And then you are making here the exception. But yes, this exception because there is a positive discrimination. In spite of we are saying that we will not discriminate, but we will discriminate for the positive reason. So this is to avoid the negative discrimination and this is to go with the positive discrimination. So women and children, state can make the special provisions. Fourth में क्या है? State can make the special provisions in the interest of minority word. ऐसे word loose word हो गए. Yes, minority. Is there constitution give us a mandate? Who are the minorities in India? नहीं पहले who are the minorities in India? नहीं इतना difficult है क्या question? बताइए आप. हाँ. So is the constitution, आप बताइए ये provision छोड़ के कि religion as a basis of providing the reservation is there in India? Technically, हाँ. So minority is not the word. Yes. What is the word then? Backwardness. Backwardness of what and whom and which? Backwardness of the region? Yes, there's very specific things. Three things: SCs, STs and OBCs भी नहीं है word. Socially and educationally backward class. Even economic नहीं है. Okay, you should mind this word. Social and educational, not social and economic. Okay, SCBCs. So state can make the provision in the interest of scheduled castes, scheduled tribes and socially and educationally backward class. ठीक है? This is a women and children. What about fifth? Yes, what is the clause 5? What is the 93rd tribe? What is scheduled tribe? Tribe is over here. Yes. What is 93rd Constitutional Amendment Act? You are right, come up. What is it? Yes, reservation in private education. Private इसलिए बोल रहे हैं क्योंकि hitherto it was not there, but it is in the education. Does not matter whether it is a private or government, aided, unaided, any kind of the education. Okay. So this is again the provision in case of reservation in educational institute. This is very specific clause only related with the education, educational institute. For the interest of class वही है. For the interest of SCs, STs and this ACBCs. There can be education. The emphasis is on education. Okay. This is, see what is the difference between the fourth and the fifth. Fourth, give you a very, very wide scope in terms of different areas. You can bring in many areas where you can give the preferential treatment to the scheduled caste and scheduled tribe. This is only related with the educational institution. This educational institution also they have mentioned that is government or private, aided or unaided. Okay, so this means that even in the private education there can be law. Okay, government and private. उसके बाद फिर से लिखा है aided and unaided. कई बार ये हो सकता है कि private institution है aided है. Aided, you understand? Okay, there is a funding from the government. So one can simply apply the logic because it is funded by the government, so obviously there can be reservation. But it is also said even if it is unaided, there will be a provision for the reservation or the protective discrimination for the SCs, STs and SCBCs. Understood? So fourth provision of this, except there is one exception. Minority educational institution will not be have this provision. Okay, all kind of institutions, government institution, private institution, aided, unaided, except minority educational institutions. Except for the minority educational institutions, because they are already in the category of minority. Okay, they are serving the linguistic and the religious minority, so there is nothing required to take their seats, etc. Okay, so that's the thing. I hope points are clear. Okay. Now, yes, ये थोड़ा सा बड़ा है, मतलब don't get, मतलब I am taking it slowly, but this constitutional 15 and 16 is very large and there are a lot many debates. Now there is also here issue regarding, okay, this educational institute and the reservation. I am just telling in 1 minute that this educational institute in case of a private was initially challenged. Okay, initially challenged in cases that how can you go for the private educational institution. Under the article 19, there is a 19 में एक clause है. What is the article 19? Freedom of speech and expression, freedom of assembly, freedom of association, freedom of travels, freedom of settlement, and last is freedom to have any profession. Okay, and there is a liberty to have a profession. So one of the profession can be establishing the educational institution. So private players are saying it's a violation of our fundamental freedom under 19 clause 1 subclause F, that is you can have the profession. So and then therefore it is for me to decide whether to give the reservation or not. This was been challenged earlier. Okay, but Supreme Court has gone with the upholding the validity that no, education, that is a private educational institutions substantially take the fund and then there are other things from the society, so it is their responsibility to go ahead with that. Okay, that reservation, particularly in the context of this 1990s where the state has reduced from the welfare state to becoming a more laissez-faire, or it has opened up the market and more private institutions have come. So in that regard, they have to take get this responsibility. Understood? So these are the 5 provision: SC, ST, socially, educationally backward class, women, and this thing. I hope, is there any issue with regard to? Please do ask, otherwise we can move to the next. There is nothing like there should be any problem here. Okay, remember this: women and children, specifically scheduled caste, scheduled tribes, and socially, educationally backward class, and the same class but educational institute, private, public, aided, unaided, except the minority institutions. Okay, now come to the 16, Article 16. What is Article 16? What is Article 16? अभी तो लिखवाया था. Yes. State will provide equality of opportunity. Article 16. Equality of opportunity in case of public employment. State will provide. Now this is one of the things which is a positively worded. That's why I said that most of the clauses are negatively worded, but not all. Okay, you should mind that word. State will provide equality of opportunity in case of public employment. एंड इसी को निगेटिव कैनोटेशन में लिखा हुआ है क्लॉज 2 में, दैट इज स्टेट विल नॉट डिस्क्रिमिनेट on the basis of 7 criterias in case of public employment. Okay, not in general. In general वाला कहाँ पे है? 15 में. Okay, 16 is employment related. 15 में its scope is very very wide. Here the scope is getting narrow into the only public employment. So 7 criterias, that is again I am not writing, the 5 same and plus residence and descent. Okay, residence and descent. Now this is again the same story like 15. Okay, this is something which we will not do, but something state requires to do in certain circumstances. Exceptions रहेंगे उसको, जैसे वहाँ पे पॉजिटिव वाला था, यहाँ पे भी कुछ पॉजिटिव करना पड़ेगा. ठीक है, इसमें है आर्टिकल 3, क्लॉज 3, क्लॉज 4 and clause 5. Okay, I will write just one word here. Okay, 3 is related with, yes, what is the exception? Residence can be criteria, is it? In certain circumstances, residence can be criteria for providing the public employment. But there is a caveat here, बहुत important है ये, बहुत बार पूछा जाता है ये. Only Parliament will make such law. Okay, if at all the residence has to be a criteria, okay, this criteria can be utilized by the state or union territory. Say for example, state government के कुछ seats occupy करने हैं, या union territory में कुछ seats occupy करने हैं, so they can give in the notification, for this occupation we require domicile of Karnataka, domicile of Maharashtra, मतलब respective state will go for it. Union territories वाले also they will put it one of the eligibility criteria that you require to be a domicile, but they themselves will not determine in which of the cases we will have this criteria. Are you understanding? They can use this criteria, but who will going to determine? Parliament. So state cannot make the law. Obviously union territory cannot make the law except Delhi and this thing, but they are not going to make the law. All such laws will be made by Parliament, okay, and which can be implemented into different states. यहाँ पे हमने लिखा था residence cannot be the discrimination, but जैसे है कि polity में, मतलब Indian polity, their son of soil and etc. employment, so some sort of reservation for those people which are living in that area. So there can be a possibility of residence as a criteria, but that cannot be arbitrary. This if the state will make a notification, okay, under the this thing, Raj Thakre will say it कि all employment should be Marathi population वगैरह. So naturally it will be challenged. Supreme Court will see that whether the Parliament has made the law. If Parliament has made the law, maybe he is right also. Okay, but obviously that is a very arbitrary कि all seats will be vacated. So obviously state will struck it down. Understood? So do not say that resident is not at all a criteria. Parliament can make. I'll come to the fourth part later. Okay, fifth के पास पहले आ जाता हूँ. Here there is a religion can also be a criteria for occupying certain public employment post. But this public employment post का nature ही क्या है? Religious nature है. Religious trust. Okay, some of the religious trusts and endowments वगैरह. So something which is a very religious in orientation. So state will make that such religious trust will be occupied by a specific person from a particular religion. So obviously the trust उसी religion का होगा, तो it is a natural to make a provision that such person from that particular religion only can occupy it. So that's very natural. We can understand that as a part of in India. See, if there is a temple and if you are putting the Muslim there, so obviously there will be a problem. And otherwise the mosque में जाके वहाँ पे मतलब शंकराचार्य को बिठा दिया, ऐसे नहीं होगा. So these two are not very controversial, not very controversial. Now this is the most important clause. Okay, this is the most important clause, that is Article 16 Clause 4. Yes, what is it? Yes, reservation for whom again? वहां पे हो गया तो यहाँ पे फिर से क्यों लिखना पड़ा उनको? Yes, what has been written? 15 में already लिखा है कि women and children, then SC, STs and socially and educationally backward class, and then educational institutes. Yes? Huh? This is particularly, yes, public employment. So, for, yes? Any backward class, that's the word. Okay. So, state can make protective discrimination, whatever the word you want to use. Okay, that is a special provisions. State can make special provision in the interest of, the word is any backward class. So therefore the scope of this become more than the 15 also, because 15 specifically mentions, yes, scheduled caste, scheduled tribes and socially and educationally backward class. यहाँ पे ये भी हो सकता है कि जो elite मतलब कास्ट से हो लेकिन उसमें इकोनॉमिक बैकवर्डनेस हो, that also can be possible. Okay, that is where many of the states are going for forward backward class. Forward backward, you are understanding? Forward class, forward caste, forward class caste के अंदर कुछ economically deprived section है. Okay, so that kind of is possible, but we will see that already the lot of drama has happened on the 16/4, so we will see that what is the present position and who are the any backward class. So special provision for the any backward class which are not adequately represented into the state. That's also important, because you cannot just put it. You have to, it means that objectively tell that this class is not adequately represented. So any backward class that is not adequately represented. So here there are two tests. One is you need to show they are backward, and second you need to show that they are not represented. It's quite possible someone is backward caste class, but there is already a good occupancy. मतलब 30%, 40% already उनका मतलब state में they have occupied the post. Okay, there are two tests here, that is any backward class and which is not adequately represented. Now, over a period of time, what has happened is, now we are coming to a very, very important case of जो Independence India के कुछ एक famous cases हैं. So there is a Mandal Commission was established. कि ये क्या है? ये any word क्या है? What is this any word? Okay, so the Mandal Commission was established. Mandal Commission was not established under Article 16 Clause 4. There is a 340 article. Article 340 क्या है? Yes, backward commission अभी है उसका नाम, लेकिन वहाँ पे president will make the certain such commission after the independence in order to see the status of backwardness and to suggest to the president what are the measures that are required to be taken for the other backward class. Are you understanding? Constitution has made a provision wherein a president time to time can establish a backward commission. What that backward commission is going to do? They are going to make a research and see the status of backwardness in India, and they are going to certainly make certain provisions and suggestions and recommendation for the president. Obviously, president is executive here. That is Council of Ministers headed by Prime Minister. Now, under this, shall I rub this? Okay. Under this, the backward commission was established. What is it name? Mandal Commission. Why Mandal? MP. Okay. कहाँ का था लेकिन? Yes, Bihar. He was the chief minister of Bihar and he was quite active in the politics. So under his name it is called as Mandal Commission. That's not important at all. Okay. Do not remember, but some will try to remember again. Okay. Mandal Commission. So Mandal Commission was established. Okay. Which government has established this? Yes, Janata Party government or Morarji Desai 1977 when they came into the power for the first time. So obviously he was also a socialist in that regard. So this Mandal Commission was established. Anyways, we'll cut short. So what is the report of Mandal Commission? Okay, 77 में establish होके 79 80 में इन्होंने immediately report दे दिया था एक साल के अंदर. Okay, तब बहुत ज़्यादा commission time नहीं लेते थे, अभी काफ़ी time लेते. So 17 and 80 में उन्होंने find out किया how much there is a 52% of population which is backward class. So 52% are backward in India. In fact, they have gone through 3, 7, 4, 3. This number is absolutely not important, but this is many number of caste. In fact, this is where the story started. उनको बोला गया कि other backward class की situation देखो, तो उन्होंने बताया कि other backward class are nothing but reflected into the caste, because caste in India is reflective of historic injustice. And therefore, even if we are saying that socially and educationally, so socially and educationally, this caste have been deprived. Okay, caste have been deprived. So therefore, the caste will nothing but class. Okay, backward class is equal to backward caste, because caste is getting reflected. Because you are asking me to find out who are socially and educationally. I know that these castes are socially and educationally backward. So he has suggested this many number of classes are backward, and the number of them in India is 52%. And therefore he has given an important suggestion here, that is a 27% of reservation to backward class. So this is where the story of the backward class reservation. Otherwise, Constitution do not provide. Okay, Constitution do not provide the reservation for the backward class. Now, what has happened later on, that's also important. He has suggested 27% of the reservation. Now, this was the year 1980. Again, the government has gone, okay, because of their internal turmoil, and also again the resurgent Indira Gandhi, 1981, she came and etc. So, Mandal Commission was, nothing has happened to Mandal Commission. 10 years down the line, okay, that is in year 1989, 90, okay. So, which government? Yes, VP Singh government. So, ये जो मंडल report था, इसको implement इन्होंने किया. Okay, so they have implemented, okay, with certain modification obviously, implemented, and they have provided the 27% of reservation. Okay, so this is where we see that the mandal politics has started. Mandal and Kamandal. What is a Kamandal? हाँ, अरे हाँ वो है, लेकिन what does it in politics represent? What is the Kamandal politics? It's not funky term, it's a political term. Kamandal politics is a saffron, yes, because one politics is on the caste base. They say that religion is an antidote. तो हम ऐसे कुछ बड़ा लाते हैं जिसमें और ज़्यादा लोग हमें वोट किया जाए. Okay, so Kamandal and Mandal politics. Mandal politics represents the backward class politics. Kamandal politics represents the religion-based politics. Mandal politics is a caste-based politics and religion-based. So Mandal and Kamandal politics, this has started. So फिर वही है, that is a Babri and yes, Babri and Babri Masjid demolition, Dadri also अभी, ठीक है, Babri to Dadri as the, yes, anyways. So that's about the VP Singh. Also later on this government, कौन सा PV Narasimha Rao है ना? PV Narasimha Rao government also made two changes. Okay, two changes here, or two additional things. One is they have applied the creamy layer criteria. Okay, they have applied the creamy layer criteria that they we will go for giving the backward class reservation is the most backward class within the backward class. मतलब creamy layer हटाएंगे तो whatever is remaining is the most backward among the backward. समझ में आया creamy layer? Okay, this is a backward class. तो इसमें से elite remove कर देंगे creamy layer, and we will give to this. So that's the first thing they have applied. Second they have applied is there are rich people जिनमें economic backwardness है. Rich people नहीं, sorry. हाँ मतलब socially yes, forward caste, socially forward caste, but there are certain poor people even within the, मतलब कोई ब्राह्मण भी गरीब हो सकता है, as a say, मतलब in that regard. So they have also provided 10% of reservation in, yes, for the elite class, जो भी लिखना है लिखो, okay, elite class में जो economically poor, yes, economically poor section within the forward community, economically weaker section within the forward community. So these two criteria. Basically, PV Narasimha Rao government tried to bring in economic criteria. So economic criteria was applied in both the cases, in OBC also, in order to remove the upper elite class, and also in the forward community, in order to take care of those poor people who are under the tag of forward community. Okay. Now this was what has happened on the Mandal case. Now everything this from here to here was challenged in the Indra Sahani case. Okay, so that's the important case. Shall I rub this? Okay. Now we will see that what has been Indra Sahani, and this has in fact settled all the debates. Indra Sahani and respectively whatever the cases. Indra Sahani case. Or this is also famously known as Mandal case. Okay, Mandal case mein this everything whatever we have discussed so far has been challenged. Now the Supreme Court is giving verdict. Whether it is upholding the particular thing or not, we will see. And plus they are adding certain more thing, how to implement this particular this reservation. First of all, the most important point, they have accepted 20% of reservation for the OBC. Okay, and that OBC will be identified as per the backward commission, that is a caste. So caste की एक list आ जाएगी. So 27% of reservation that has been upholded. जो VP सिंह ने लगाया था that has been upholded. अब नरसिंह राव ने जो 10% लगाया था that has not been accepted by Supreme Court. They have said that this providing for the economically poor section within the forward class, that has not been validated. Therefore, we do not see now that reservation is there. Second thing was what they have said about creamier. दो थे ना PV Narasimha Rao की. So creamier they have validated. Okay, creamier they have said yes, but only for the. Okay, anyways, यहाँ पे लिखो, पहले मैं पूरा बता देता हूँ. Even when the 27% of reservation there, the ceiling is also been mentioned. Okay, final ceiling 50%. That any kind of the reservation will not go beyond the 50%. Next is reservation will be limited only to entry point and not to promotion. Remember that when it is saying that not to promotion, it is not saying only for the OBC. Supreme Court is saying that not even for SC, not even for OBC, not for anyone. We will see that बाद में क्या change हुआ है, but Supreme Court in the Indra Sahani case saying all kind of reservation. These two are for everyone. 50%, मतलब SC, ST, OBC, whatever the permutation combination you give, we don't care about it. It has to be 50% because we have to maintain the efficiency, excellence, merit, that also. So there has to be a balance between the positive discrimination on one side and the maintaining the efficiency and the merit on the other side. So therefore 50% is your chance. Okay. Second is about reservation. Okay, if it is a positive discrimination, so obviously once you will give the reservation, he will get certain avenues. So it means that entry point is fine, promotion is not required. It will be based upon the promotion. In fact, there is one more point which I will see, I'll come later on. They have said that in fact the reservation cannot be given in certain super specialty cases. Okay, there are certain jobs which can be filled up only by merit. Okay, जैसा है कि medical में super specialty के jobs हैं. Okay, that can be filled only by merit. I'll see that debate later on. क्या हो गया उस debate के ऊपर. But remember this, reservation is given, but there are three conditions have been applied. One is the creamier. Okay, creamier, that is yes, I hope the point is clear, nothing to explain. Creamy layer, ceiling will be there and reservation only for the entry point. Now this has now since Supreme Court also has accepted, so this becomes the start. Indira Sahani case हो गया, and obviously the 27% reservation has applied. In this regard, in 27% of कौन OBC है, इसके लिए उन्होंने ये भी बताया कि state should establish the backward commission, okay, statute. तो बैकवर्ड कमीशन जो है 1992-93 जो भी ईयर होगा, सो द स्टैट्यूट से इस्टेब्लिश किया गया बैकवर्ड कमीशन इन ऑर्डर टू सी the inclusiveness and the exclusiveness. Time and time they will see कि which backward class require reservation, therefore उस कास्ट का नाम ऐड कर दिया जाएगा. कौन सी कास्ट ऑलरेडी रिजर्वेशन के कारण अब yes they have achieved the excellence, उनका नाम एक्सक्लूड कर दिया जाएगा. बट ये इंडिया में नहीं होता है, एक्सक्लूड का तो कोई मतलब चांस ही नहीं है. ऑब्वियसली द वोट बैंक, इट इज़ ओनली द इंक्लूजन. ओके, सो और इंक्लूजन these are the aspects which will be there. Okay, so time and again you see that backward class commission की अगर side देखोगे तो उसके जो notification रहता है, time and again they will see that this is the changes we are making with every single notification. So that's about the backward commission, creamy layer, ceiling and reservation. Now come to here, that is about the second case. So first case, first thing that we are debating within the article 16 क्लॉज 4 जो था, यहाँ पे क्या लिखा था, एनी बैकवर्ड क्लास. सो एनी बैकवर्ड क्लास से अब ये भी आ गया कि दैट इज इट कैन बी प्रोवाइडेड. बट नाउ द प्रॉब्लम केम रिगार्डिंग द प्रमोशन. What is the promotion? Is there promotion for the OBC today? Is there any promotion for the OBC today? Are?
But you sometimes see that if they are not represented,
हाँ, okay. Okay, for whom? That is important.
That's for SCs, STs.
हाँ, that is for SCs and ST. OBCs there is no promotion at all. Okay, reservation in promotion. Okay, so whatever the case of Indira Sahani regarding the promotion, that is remains so for the OBC class. OBC class के लिए केवल entry point के लिए, and that is 27%. In case of SCs and STs, the situation got changed. Okay. आफ्टर इसको नलिफाई करने के लिए, किस चीज़ को, दैट इज़ अ प्रमोशन को नलिफाई करने के लिए देयर वाज अ 77th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट. 77th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट. सो 77th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट मेंटेन्ड दैट फॉर SCs and STs, अगेन हियर द वर्ड इज नॉट देयर socially, educationally or OBC, only for two there will be promotion. Only for there will be a promotion. Now this is how the promotion is done. What is the word that has been mentioned? I'll come to one more word. Promotion on the basis of consequential seniority. Is this word is there or not? Have you come across this word? How the promotion is done? Roster system पता है? Consequential majority. Okay, little bit of complicated thing is there. If you want, I can explain in 5 minutes. Otherwise, we can leave also. So it's up to you. Explain. वो UPSC नहीं पूछने वाले, ठीक है, for sure. Then leave it. Okay, that is the approach. एकदम मतलब total utilitarian approach है. Marks कहाँ से आएंगे हमें बताओ उतना. See, the thing is that they follow what is known as roster system. ठीक है, रोस्टर सिस्टम में मतलब एक एग्जांपल दे रहा हूँ, 100 सीट्स फिलअप करने हैं. तो रोस्टर में ये होता है कि अब ये नहीं है कि एकदम स्पोरेडिकली 100 सीट्स वैकेंट हो जाते हैं. ओके, इट बेस्ड अपॉन रिटायरमेंट, ट्रांसफ़र एक्सेट्रा. सो एक साल में समझो 10 सीट वैकेंट हो रहे हैं. तो वो रहेंगे कि जनरल कैंडिडेट के 5, SC के 2, ST के 2, एक आधा और ऐसे 10 हो गए क्या? ठीक है. So say for example this is for SC, this is ST and this is OBC तो नहीं लिख सकता, ठीक है, 2 ये लिखो, ठीक है. So this is for general candidate. Now what is happening is this seat can be filled up by general also, and SC will also get the chance and ST will also get the chance here. Now, say for example, let's take an example of two different individuals. There is an individual A and individual B. Individual A is from the general category and this is from the SC or ST category. He is a 5-year senior to it. A वाला person. Now what is happening? यहाँ पे अगर जनरल का रोस्टर ये साल में नहीं निकला है, केवल SC का निकला है और SC has taken that particular seat. Okay, he is getting the promotional seat even before because इसके SC के लिए कितना हो गया? 5+2 chances है. Are you understanding? He is getting 5 also and he is getting 2 also. So क्या होता है कि 2 में इन्होंने ऑक्युपाई कर दिया वो सीट. ये 5 के लिए वेट करते रहेंगे. Okay. So say for example 2 year down or on that particular day B has gone into the promotion because he fall into this roster. समझ में आ रहा है नहीं आ रहा है? Okay, उनका SC की सीट खाली थी तो उन्होंने प्रमोट हो गए यहाँ पे. Now the moment he is going in the promotion, that is a B dash लिखता हूँ promotion के बाद, 5 साल के बाद say for example 3 साल के बाद इनका भी प्रमोशन हो गया. ठीक है, but the point is B is now senior because at that particular post he is 2 years ahead of this. So what is happening here? The 5 years ये यहाँ पे हो गया था लेकिन अब 2 साल ये जूनियर हो गया इसका. मतलब there is a loss of 7 years because the worthy seat he would have got otherwise becomes 3 years late and 2 साल का इनको promotion मिल गया. Are you understanding? So SC and ST person becomes the still ahead of him in case of seniority. So when the 77 Constitutional Amendment Act has said SC ST can be promoted, this has started happening. Understood? So इसको ख़त्म करने के लिए अब ये इधर से सुप्रीम कोर्ट ये कॉन्स्टिट्यूशनल अमेंडमेंट करते रहेंगे, सुप्रीम कोर्ट उसको नलिफाई करता रहेगा. सुप्रीम कोर्ट ने क्या किया? रोस्टर सिस्टम गॉट कन्वर्टेड इनटू और एक क्लॉज इंट्रोड्यूस किया कैचअप. ओके, कैचअप क्लॉज. ओके, कैचअप क्लॉज में क्या है? नो मैटर इवन इफ ही विल गो 3 years later, द मोमेंट ही विल बी ज्वाइनिंग द बी, तो बी की सीनियोरिटी मिल जाएगी इनको. It means that because he would have otherwise eligible for the seniority 3 years back only, but because he was not SC, he didn't get it. Are you understanding? If you are not understanding, it does not make any difference. ठीक है? Yes. So कैचअप में जो 3 साल का जो लॉस बताया था वो नहीं होगा because you are already equal and therefore you get the same seniority. तो इस कैचअप को एंड करने के लिए दे हैव कम अप विथ अगेन 1 कॉन्स्टिट्यूशनल अमेंडमेंट. अगर नहीं याद है तो 2 बस नाम याद रखो. 85th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट. इसमें द वर्ड प्रमोशन की जगह प्रमोशन ऑन द बेसिस ऑफ कॉन्सिक्वेंशियल सीनियरिटी ऐड किया गया. ठीक है, कॉन्सिक्वेंशियल सीनियरिटी से वही सिचुएशन फिर से वापस आ गई जो रोस्टर टाइप वाली सिस्टम है. ओके, क्रूड के लिए आपको समझा रहा हूँ. द सेम थिंग हैज़ बिकम okay in place. Understood? okay, नागराजन केस में इसको चैलेंज किया गया. नागराजन केस में अब जो है, जो आप बता रहे थे कि SC एंड ST का जो प्रमोशन होता है तो 3 क्राइटेरियाज नागराजन केस ने दिए. दैट yes you can go for the promotion but you have to ensure 3 things. First thing is you have to ensure the backwardness. First thing is you have to ensure the backwardness because now it is a promotional. प्रमोशन में मतलब ऑलरेडी अगर कोई SC एंड ST है और वो 15 ईयर हो चुका है उनका, इज ही स्टिल अ बैकवर्ड? दैट यू हैव टू शो. दैट इज फर्स्ट थिंग. सेकेंड इज दैट इज अ रिप्रेजेंटेशन दैट दे आर नॉट एडिक्वेटली रिप्रेजेंटेड. ओके, सो दैट इज व्हाट यू आर सेइंग. दैट इज इन प्रमोशन यू नीड नॉट रिक्वायर टू शो दैट. ओके, इन केस ऑफ द फर्स्ट एंट्री, backwardness, representation, and third is you have to show that this promotion will not dilute the efficiency of administration. It is not going to dilute the efficiency. So these 3 criteria where Supreme Court came up with, go for the promotion, do whatever roster system or whatever the system is, you go for these 3. इसके बाद this Bihar High Court and the Rajasthan High Court many a times have struck down. मतलब जो राजस्थान में ऐसे ही प्रमोशन दे दिया था विदाउट गोइंग फॉर 3 क्राइटेरिया. बेसिकली सबसे इंपॉर्टेंट क्राइटेरिया यहाँ पे आपको when you have to show backwardness and inadequacy of representation, you have to come up with objective data You have to display the objectively that yes, there is a backwardness, and you have to objectively through the data demonstrate yes, there is a lack of representation. This was a very difficult, therefore Rajasthan and Bihar has gone just like that, and then it has been scrapped down also. Okay. Now, in order to scrap 3 criterias, there is one constitutional amendment which is pending. You must be reading in the news now, 117th bill, जो bill है, 117 bill, constitutional amendment bill 117. 117 is trying to nullify कि ये 3 criteria नहीं चाहिए, just tag of SC and ST is enough to give the promotion. Understood? Again, नहीं आ रहा है तो छोड़ दो सब कुछ. Okay, just remember that what has happened in the Indira Sahani cases, 27% of the reservation for the OBC, creamier only for the OBC. This ceiling is already there, and reservation for the entry only for the OBC, but promotion के लिए SCs and STs. Okay, on the basis of this criteria. That's it. At least you should remember. I hope points are clear. Okay, so this is about, yes. Promotion is any class of jobs. Okay, yes. एक है कि जो सुपर स्पेशलिटी जॉब्स बता रहा था मैं, दैट्स द थर्ड थिंग. मतलब ये तो दूसरा हो गया कि फर्स्ट आई हैव सेड रिजर्वेशन किसके लिए है, सेकंड प्रमोशन में किसको है, दैट इज एससी एंड एसटीज, एंड देयर आर सर्टन जॉब्स विच आर कॉल्ड एज अ मेरिट बेस्ड जॉब्स. तो उसमें रिजर्वेशन नहीं है. बट अभी जो एम्स में केस हुआ था, एम्स फैकल्टी वर्सेस स्टेट ऑफ इंडिया केस, उसमें उस केस में सुप्रीम कोर्ट ने कहा कि ठीक है, यू कैन गिव द प्रमोशन इन सच केसेस ऑल्सो. सो दे हैव पुट द बॉल इनटू द legislative court that now the legislature over a period of time will come up with some constitutional amendment stating that even in case of super speciality reservation can be given. Okay, so that has, the debate has been, पहले जो एम्स का जो केस था सुपर स्पेशलिटी वाला, Supreme Court has said no first, but there is something called as review petition. I hope everybody is knowing about it. There is a review petition. Review petition में वो change हो गया. पहले Supreme Court has denied it that special job will be reserved only for the merit. Then there was a review petition. Review petition में उन्होंने yes नहीं बोला. उन्होंने बोला कि we will leave it to the wisdom of the legislature. Okay, something that they are saying in case of Uniform Civil Code, something that they are saying in case of 377 LGBT rights. But the Supreme Court is saying, okay, that IPC section 377 has to go. Okay, so it is for the parliamentarians to change the law. Okay, in case of a UCC also they are saying the same. Have you got this? Okay, so this is about the whole story of yes, that is about 15 and 16 reservation. See, the thing is that 15 scope is very big because it's not just public employment. It can be anything. For anything you can go for it. Say for example, government की policies है और policy में कुछ एक आपको focus करना है SC, ST and OBC population के लिए in order to distribute the resources. So you can keep the criteria that eligibility for this particular thing. Say for example, housing allocate करना है आपको, housing के लिए allocation करना है. This is not a public employment. This is allocation. Allocation में भी आप criteria रखा सकते हो. So that criteria will come under 16 or 15. 15. Sorry, 15. Yes, it will not be 16. 16 is public employment. Okay. Is that fine? Okay. So go to the next. That is about, आज टेस्ट नहीं है, सो चिल आउट. मतलब क्योंकि दो एक हाँ, इन वन गो वी हैव टू डू इट. टुडे वी हैव टू फिनिश फंडामेंटल राइट्स एंड रेस्ट ऑफ द डायरेक्टिव प्रिंसिपल है, फिर यू हैव टू राइट द टेस्ट. ओके, सो लेट अस फिनिश दिस 2 आर्टिकल्स एट लीस्ट. यू वांट अ ब्रेक? नो नो ब्रेक, फिर जाओगे फिर आओगे, आधा घंटा लग जाएगा. ओके, जस्ट स्टे फॉर टिल 6 वी कैन फिनिश. ओके, अब बाकी के 2 आर्टिकल बहुत छोटे छोटे हैं और एक 19 है, लिखो. या फिर नेक्स्ट आर्टिकल. यस, व्हाट इज द नेक्स्ट आर्टिकल? आर यू फॉलोइंग मी, ऑल ऑफ यू, इवन द सब क्लॉजेस? यस, लास्ट रो, बालकनी. यस, ऑल ऑफ यू आर फॉलोइंग? यस, ओके. नहीं तो मूवी चल रहा है, कॉम्प्लेक्स मैट्रिक्स मूवी समझ में भी नहीं आ रहा है. कितने क्लॉज है, क्या है? Yes, next two are basically to remove some of the inequalities, prevailing inequalities. First is Article 17, that is a abolition of untouchability. See here there are three things. A clause वगैरह कुछ नहीं है. Abolition of untouchability. मतलब Constitution declares that there is abolition of untouchability. But Constitution also knows that it can be practiced. Okay, so they say that abolition of untouchability and practice of its any form is forbidden. Okay, practice of any form of untouchability is forbidden. Yes, can you tell me some of the forms of untouchability that has been practiced still? Yes, places of worship. Okay, so temple entry still they are still denied with the entry. Yes, what else? Manual scavenging. Okay, most of the times the people who are pushed into that is these people. Yes, what else? Many a times they have been denied, okay, access still to the public places or public these tanks, etc. If you go into the rural area, the situation has not been changed yet. Okay, so bonded labor and some sort of still it has been practiced. So any form of untouchability is a forbidden, and it will be considered as offense. Okay, if at all doing under the law. Okay, in this regard, you have laws should be made. So eventually, the Parliament is making the law. Okay, eventually, see there are certain articles which you don't require to make a law. Okay, they are already matlab enforceable. But there are certain articles which required complementary law to be there. Parliament should take the cue from the articles, and therefore they should make the law. Okay, in order to give the more meaning to the law. Otherwise, there is no meaning. If you are putting, if there is offense and if there is no law, so who is going to deal with it? Okay, so what is the law that has come into picture? Yes, what is the name of law? Huh? What is the law on untouchability? Is that difficult? Protection of civil rights. Protection of civil rights. Earlier it used to be known as Untouchability Abolition Act. Untouchability Abolition Act, but now the name has been changed. Yes, कब change हुआ है? 77, I think, 1977. Okay, so it was known as Untouchability Act. Now it becomes the Protection of Civil Rights Acts. So protection of civil right, basically, in fact, it's not just the change the name, it has made the law more stringent. Okay, that is a non-compoundable and non-cognizable offense. What do you understand by non-compoundable and non-cognizable? Yes, any lawyer sitting here? What is non-compoundable? Can't take back from non-compoundable is you cannot make the compromise. Settlement nahi kar sakte because this is a very serious crime. Now the law will take its own course. Say for example, there is a rape case hai, murder hai, heinous crime jo rehte hai, you cannot take back the case, okay, by having a compromise because the crime is very serious. So now it has made the non-compoundable. That is non-compoundable. What is non-cognizable? बेल वगैरह नहीं दी जाती है, बेल में डिफिकल्टी आती है. सेकेंड थिंग, अरेस्ट कैन बी मेड विदाउट मैजिस्टेरियल वारंट. Okay, that is non-cognizable. Anyways, just remember that it has made more stringent, and also there will be a provision for fast track courts for this. Okay, in order to like pendency nahi rahe aise cases mein. So we are getting more serious on this by increasing the punishment and also by increasing the speed of delivery of justice. Okay, so that's about the Protection of Civil Right Act and abolition of untouchability. There is one more act, second, yes, very famous. That is a Scheduled Caste and Scheduled Tribe Atrocity Prevention Act. Scheduled Caste and Scheduled Tribe Atrocity Prevention Act, okay, or Atrocity Act. इसके अंडर क्या होता है? Yes, Atrocity Act, जो famously it is known as atrocities cases. What does it happen?
Even with the speech they try to spread.
Incitement, or it's more than that. Atrocity, what is atrocity? Not just about the speech. Okay, exploitation also. Yes, okay. Yes, exploitation है यहाँ पे basically abuse, exploitation, crime against the exploitation, crime, abuse against the SCs and STs. So basically that is a elite class committing the atrocities against this SCs and STs. So इसके अंडर law में क्या क्या provision है? Yes, any famous provisions you know? What happens in this? See, generally the license which are given, okay, sometimes there are license which are मतलब people acquire the license. License समझ रहे हो किसके लिए license? Guns and bullets and arms रखने के लिए. So there can be a taking away of the license from the rich class. There will be a more vigilance in this regard. क्यों rich class मतलब they are committing the atrocities against this thing. So license is given. There is also provision of compensatory justice. Compensatory justice मतलब क्या रहता है? For the for victims. So victims के लिए atrocity. कई बार क्या होता है कि what does the in case of India there is not much focus on the compensatory justice. अब जैसे है अगर सलमान खान का केस आपने देखा होगा, okay, forget about he is to now acquitted completely. But earlier time also when the person who died and उसके घर में जाके पूछा कि सलमान खान को जेल हो गई है, आपको कैसे फील हो रहा है? Now उनका इतने गरीब है वो कि सलमान खान जेल में जाए ना जाए, it does not make any difference to them. They are saying that our breadwinner has gone, and even if he will be jail and he will not be jail, we are not going to get a single penny. So how it is going to matter for us? मतलब वो दिल को तसल्ली हो गई, but there is no compensatory justice. Compensatory justice is victim also be given some sort of compensation. So here is the case where we see the provision for the compensatory justice as well. Not only there will be action against the dominant section who are trying to commit the atrocity, but there will be an compensation given to the victims also. Okay, and if it is required, victims के protection के लिए उनको license दिए जाएंगे. If there is a lot of threat to them, so they will be provided with the license to have the arms in order to protect that particular community. Are you understanding? So atrocities cases are these also invite you the disqualification. Okay, that is untouchability, और इसके अंदर अगर आप वो होगे तो that is a disqualification for the इनके electoral offenses जिसको बोला जाता है. Okay, in this category they fall. Disqualification for fighting the election, MLAs and MPs का election. Okay, so this is about abolition of untouchability. प्रोविजन तो इम्पॉर्टेंट ही है, बट प्रोविजन के अंडर आपको वहाँ पे जो लॉ वर्ड दिया गया है, एंड दैट लॉ कैन बी फॉर्म्ड ओनली बाय द पार्लियामेंट. ओके, दिस इज वी आर गोइंग टू लर्न इन आर्टिकल 35. आर्टिकल 35 सेज जो लास्ट लॉ है फंडामेंटल राइट्स का, कि पार्लियामेंट शुड मेक द लॉ इन सर्टन एरियाज इन ऑर्डर टू गिव द मोर मीनिंग टू द फंडामेंटल राइट्स दैट हैव बीन रिटन इन द पार्ट 3. Point is clear? Okay, now come to the article. Next article, that is article 18. Yes, what is article 18? Yes, abolition of titles. ये एक काफ़ी टाइम क्वेश्चन पूछा जाता है प्रीलिम्स में, कौन टाइटल ले सकता है, कौन टाइटल नहीं ले सकता, किसको, मतलब व्हाट इज द कॉन्स्टिट्यूशनल प्रोविजंस. Abolition of titles. Abolition of titles. Yes, there are 3 to 4 provisions. 4 provisions है इसके अंदर. Okay. First of all, see what is why it is under the equality provisions, because if you grant the title, okay, there will be yes, differences, elitism will be created in the society. So it will go against the principle of equality. So first, I'm not writing the exact provision, only writing the gist. Okay. So the first is the Indian state will not grant any title except for the military and military and academic excellence. Military and academic excellence. So it means that for the military and for the academic excellence, it can be given. Okay, it can be given. But otherwise, they will not give altu faltu titles in order to create unnecessarily the gap in between the rich and the poor. Okay, that's the first thing. Second thing is regarding with the citizen of India. अब ये तो नहीं देंगे citizen of India whether they can take up the title or not. State से लेने का कोई chance ही नहीं है. We need not have to write this specific provision. It was not required to write कि citizen of India should not accept the title from the Indian state. इसका मतलब ये है कि आपने पहले लिख दिया कि हम नहीं देंगे. इधर लिखने का कोई point ही नहीं है वो कि citizen of India will not accept from the Indian state. So what is there? Citizen of India will not accept the title from foreign. तो इसको कभी कभी मतलब बहुत ज़्यादा CSAT की प्रैक्टिस करने के बाद ऐसे लगता है कि citizen of India will not accept the title from foreign, so maybe they can accept the title from state. No, it has to be read with this. Okay, state देगा ही नहीं तो कहाँ से आएगा? Okay, that is a foolish to write again and again. Understood? For the citizen, they will not or they cannot accept the title from the foreign countries. Third thing, what about the foreign citizens? Foreign citizens having sort of any public trust or any kind of the office they are holding in India, such foreign individuals. Okay, बाकी तो foreign individuals आएंगे जाएंगे. Okay, those foreign individuals who are some sort of is there any post in case of a government, all such foreign citizens cannot accept. Okay, पहले तो इंडिया से तो कोई इशू ही नहीं है. From the foreign countries they can. Okay, provided they should take the permission. So they can take up the titles, but permission is required. Can take up the titles obviously from foreign because India is not providing. Okay. India is not providing, so they can take up the titles from the foreign countries with permission of president. Okay, and then the finally fourth point. What is the fourth point? It is not written Indian citizen or any person. The word is not title. Title is written only for the three provisions only. So any person can accept the gift or emoluments or any foreign office from the foreign with the permission of president. So let me come to say this. Maybe Indians can accept the gift, emoluments and the official posting. Here the word is not title. So for the citizen of India, you cannot accept inside outside. Inside देगा नहीं, outside लेना नहीं है. Foreign के लिए inside का chance नहीं है because India will not grant. Outside you can take up but with the permission. This clause is not related with the title, it is related with the gift, emoluments and office which person can take from foreign, okay, with the consent of president. This can be maybe, matlab Indian citizen can also take gift, emoluments, not titles. So titles are related तीन ही provision है. Fourth provision is basically related with the gifts, emoluments and the offices which can be done by the both. यहाँ पे Indian citizen भी आएगा और दोनों आएंगे. Now slightly there is one debate है वही कि are there titles or this Padma Bhushan, Padma Vibhushan and yes Padma Shri. What about that? If you are calling that state will not give the titles, then why the state is giving? then they say that they are not the titles to create the inequalities. They are just to recognize the contribution of the people towards the society. And there is also a caveat that they should not use, even if the state will grant, जो कि आप किसी भी अगर प्रोग्राम में जाओगे तो वो पहले लिखा होगा पद्मश्री ये यहाँ पे पधारे हुए हैं या पद्म विभूषण बैठे हुए हैं व्यासपीठ के ऊपर. Actually it is wrong. Okay, they have declared that nobody should use it as a prefix, okay, or otherwise also. So it's just a mere recognition, but that recognition does not should lead into creation of that so-called inequalities. So giving the Padma Shri, Padma Vibhushan and Bharat Ratna is okay as per the constitution, but using this title for any kind of a purpose as a part of a prefix and as a kind of a title is not permissible. ठीक है. So the next time when you will see such व्यासपीठ के ऊपर पद्मश्री सचिन तेंदुलकर या फिर अनुपम खेर, पद्मश्री अनुपम खेर, तो you can मतलब obviously raise the voice. ठीक है. हाँ, yes it is. ऐसे लॉ ने नहीं बताया कि उनको पनिशमेंट होगा, लेकिन ऑब्वियसली यू कैन चैलेंज इन द सुप्रीम कोर्ट एंड देन द सुप्रीम कोर्ट मे कम विद द मे बी एनी डॉक्ट्रिन, और क्या पता मतलब क्या होगा. आपका नाम आ जाएगा दिस वर्सेस स्टेट ऑफ इंडिया. ठीक है. सो यस, सो दीज आर द एस्पेक्ट. शैल वी टेक 19 ऑल्सो? एक लेते हैं 19. ओके, सो राइट द नेक्स्ट. एनी प्रॉब्लम सो फार? ओके, लेट्स कम टू द 19. Article 19, again, one of the most important, most debated, most controversial, complex article within the fundamental rights. I will not write complete wala, matlab right of liberty में 19, 20, 21 and 22 are there. So we'll start with the, that is the second category of right चालू हो रहा है मेरे. क्या है? Right to freedom. Okay, that is a broader title. Second category of right. इसके अंदर okay, that is article 19, 20, 21, 22 and 21A. Okay, these are the rights. So this we are going to discuss later, but 19 आज discuss कर लेते. Article 19. Yes, what is Article 19? Freedom of speech and expression. Freedom of speech and expression. ये इसको थोड़ा सा और डिटेल में करना पड़ेगा क्योंकि there are certain rights. So freedom of speech and expression itself involve 6 small rights. So I am writing here Article 19, freedom of speech, अरे मार्कर दे देना जरा नया, speech and expression. So this involves 6 types of rights. Okay, so this is like 19 clause 1 सब clause है इसके अंदर. A B C D E F G जो भी है. A क्या है? Speech and expression. Yes, freedom of speech and expression. Second B, freedom of assembly. Assembly आगे क्या है? इस विदाउट आर्म. ऐसा नहीं है कि फ्रीडम ऑफ स्पीच मतलब गन्स बुलेट्स लेके एकदम इकट्ठे हो गए. ओके, विदाउट आर्म, अनआर्म्ड असेंबली, पीसफुल असेंबली, पीसफुल एंड विदाउट आर्म. सी, व्हाट इज इट? फ्रीडम ऑफ एसोसिएशन. फ्रीडम ऑफ एसोसिएशन. डी, फ्रीडम ऑफ movement. E, freedom of settlement, resident settlement, you can settle in any part. And F नहीं है, G है. F कहाँ चला गया? हाँ 300. What was it? It was related with property. So F has gone. G, freedom of profession. So these are the 6 freedom given under this. Okay, that is a 19 clause A. Sub clause की जरूरत नहीं है, लेकिन clause A you should know. That is, it is a 19(1). Now, one of the characteristics feature, okay, of this particular freedom is the restrictions are also mentioned in the same article. Okay, so on each 6 of them there are certain restrictions. It is not absolute. Freedom of speech and expression, it does not give you right to make the hate speeches and so on and so forth. There are certain reasonable restrictions. So I'll put it here that what are the reasonable restrictions? Reasonable restrictions. So even if the right is given, we have discussed that there are all rights, एक special picture देखा था, all rights are not absolute. There are reasonable restrictions. So freedom of speech and expression के ऊपर there are 8 restrictions. Okay, 8 category. Okay, that is just you can mention here, that is a sovereignty and integrity, then security of country, then friendly relation with neighboring countries. मतलब आप सुबह उठ के बोल रहे हो पाकिस्तान बेकार है, पाकिस्तान ये है, पाकिस्तान वो है, फिर पता चला कि पाकिस्तान हमसे बात ही नहीं कर रहा है, ठीक है? So if the you cannot make such speeches, अमेरिका बकवास है या फिर ऐसे sort of things, you cannot make the statement. It may hamper the, so your freedom of speech and expression will not give a chance to make a lot of criticism. Okay, that is a neighboring country. अब ये neighboring countries मतलब neighboring RT countries मत पकड़ो. So obviously that becomes all sovereignty and integrity, security, friendly relation with neighboring countries, public order, morality, contempt of court, defamation, and incitement to violence. Incitement to violence. Okay, one of the important myths here is sedition. Okay, sedition has not been included, and this was it was not by chance. Okay, it was not by chance कि अब sedition के ऊपर इतना है. It was not by chance. Constitutional Assembly then discussed a lot should the sedition will be included or not, and the decision was made against it. Okay, that it should not be sedition, because sedition is a very, very high level of crime, and therefore it has been retained in the IPC section. Okay, that is which is the section 124. Okay, 124A. So sedition charges, that is a disaffection with the nation which is accompanied by the violence. Okay, so that is the thing here. These are the 8. Freedom of assembly के ऊपर कितने restriction है? 3 ही restriction है. Sovereignty and integrity, and then public order. 2 ही है basically. Public order. There are only 2 restrictions on the assembly. Here freedom of association, there are 3. ये 2 वही है, that is sovereignty and integrity, public order and morality. Yes, association के ऊपर there is a morality also. There are 3. Freedom of movement and settlement इन दोनों के लिए combined है. इन दोनों के लिए combined है. There are 2 restrictions. Yes, एटलीस्ट एक तो बता सकते हो. हाँ, शेड्यूल ट्राइब, और क्योंकि शेड्यूल ट्राइब का कल्चर कैसा है, दे आर नॉट मेन स्ट्रीम्ड, देयर कल्चर इज़ वेरी यूनिक. आप कल को बोलोगे कि मुझे ट्राइबल एरिया में जाके सेटल होना है, वहाँ पे कैसल बनाना है, एक्सेट्रा एक्सेट्रा. सो दैट इज़ नॉट करेक्ट, बिकॉज it will be like uprooting the culture of the tribal areas. That is one. So यहाँ पे general public interest, general public interest or larger public interest and scheduled tribes, in the interest of scheduled tribes. Remember this properly, it is not scheduled caste, okay, or both, matlab jo rehta hai scheduled caste and scheduled tribes, that's also related only with the movement and settlement, not for rest of the things, okay. So you cannot move into that particular area for the interest of, because ultimately जैसे है कि जारावा ट्राइब्स है वहाँ पे जाके टूरिज्म मतलब आप कर रहे हो, उनको देख रहे हो एक्सेट्रा, मतलब एज इफ दे आर नॉट ह्यूमन बींग्स, सो दैट मूवमेंट कैन बी रिस्ट्रिक्टेड, वहाँ पे जाके सेटल होना तो और तो दूर की बात है, ठीक है. सो व्हाट कैन बी द जनरल पब्लिक इंटरेस्ट, where the movement can be stopped for the general public interest. What can be the other general public interest? Hygiene, okay, yes. Red light area hai, prostitution ka area, you can put certain restrictions that you should not enter into this. What else? कोई एंडेमिक एरिया है, HIV एड्स या फिर ऐसे, मतलब कोई भी हो सकता है, ओके. हाँ बट ऐसा नहीं, हाँ रिपीटेड ऑफेंडर्स को कैसे मतलब okay, fine, thoda sa, yes, the one who is notorious for making the hate speeches going there and this thing and causing a lot of turmoil and inciting the violence and etc, okay. So Akbaruddin, okay, उनका बड़ा भाई नहीं, बड़ा भाई थोड़ा he is fine, मतलब क्या नाम है, हाँ असादुद्दीन is fine, okay, या फिर राज ठाकरे है, okay, उनके लिए तो रिस्ट्रिक्शन यहाँ पे लगा, ये एक नहीं जाएगा तो 1000 जाके वहाँ पे वैंडलाइज करके आएंगे. So either way he is going to make speeches, I think that is fine because it is a verbal. Otherwise if he will not reach, then there will be a vandalization. Okay, anyways, so that's the point here, that is if it is in the general public interest not to allow someone and restrict the freedom of movement and the settlement, one can do so, and with the that is a scheduled tribes also, okay. The last, that is this profession. Profession में क्या exceptions है? इस प्रोफेशन में थोड़ा सा टिपिकल है, दैट इज अ स्टेट विल रिजर्व सम एरिया. प्रोफेशन में एक्चुअली व्हाट इज दिस कंप्लीटली, फ्रीडम ऑफ प्रोफेशन एंड फ्रीडम ऑफ ट्रेड एंड कॉमर्स. फ्रीडम ऑफ प्रोफेशन, फ्रीडम ऑफ ट्रेड, कॉमर्स, ऑक्यूपेशन. You can have any kind of occupation, you can have any kind of a trading profession, etc. So profession है तो obviously natural क्या रहेगा, एक state can make specific qualification required for certain profession. So state can make specific qualification. That can be a restriction. मतलब ऐसा है कि डॉक्टर is earning lot of money, therefore qualification नहीं कुछ नहीं, मतलब चालू कर दो, मतलब you have opened the this OPD and asking yes, मतलब एकदम cheap rate में मैं I will provide the medical health care. That cannot be possible, okay. That is a certain minimum qualification is required. That is the first. What is the second? This is the one exception. So specific qualification for specific occupation, any kind of occupation they can put. It is a very logical to understand. Second, what is the second, that state can exclude personal person from certain occupations and commerce. मतलब there can be a complete monopoly. जैसे डिफेंस सेक्टर है या न्यूक्लियर पावर सेक्टर है, some sensitive areas if they feel should not be open for the profession, मतलब private person के लिए. So a state can exclude a person for certain commerce, certain trade, certain particular occupation, okay, and it can do so, exclude partially or exclude completely. Completely हो गया तो it's a complete monopoly, and partially मतलब कुछ एक restriction लगा देगा कि इतना ही आप कर सकते हो, इतना नहीं कर सकते, sort of thing. Understanding? So these are the aspects which you can say that as a part of a profession or otherwise लिखा हुआ है. Okay, remember this thing, that state can exclude or otherwise में, जैसे say for example cases like prostitution. Okay, there is a lot of debate if you are sometimes discuss in paper 4. There are good reasons to make the legalization of prostitution and LGBT rights, etc. Those are the ethical debates. But here there can be a possibility that you cannot take such profession, otherwise जो word है तो उसमें आ सकता है वो, ठीक है. आर यू अंडरस्टैंडिंग? सो दिस इज बेसिकली the what are the provisions. There are 6 provisions and correspondingly there are certain exceptions also. Please remember some of the exceptions. Generally also, if you can matlab put it this way, कि freedom of speech and expression, there are lot many expressions. Here there are only 2 and 3. Here there are common. Again we have understood. If you remember a sort of a story type, जैसे ये बताया था अभी कि movement and settlements, scheduled tribes and this thing. 1 or 2 examples you can remember. It will not be very difficult for you to remember these things. Okay, so these are the freedom of speech and expression in assembly. Yes, I am going to take again 5-10 minutes more. Okay, in order to discuss some of the things within this, you can just write इसमें इसके अंदर कुछ implicit articles है. Okay, just one line for each one of them. ये तो exceptions लिखा हुआ है, थोड़ा सा देखते हैं इसके अंदर क्या detailed provisions आ सकते हैं. Freedom of speech and expression के अंदर कौन कौन से फंडामेंटल राइट्स नाउ इट हैज़ बीन ग्रांटेड. यस, व्हाट ऑल फंडामेंटल राइट्स हैव बीन ग्रांटेड? वेरी फेमस वन, एटलीस्ट देयर आर 5-6. यू शुड एबल टू टेल वन. फ्रीडम ऑफ प्रेस. यस, फ्रीडम ऑफ, इवन मोर इम्पॉर्टेंट देन दैट विच वी डिस्कस एवरी डे, फ्रीडम ऑफ राइट टू इंफॉर्मेशन. Okay, right to information is emanating from the freedom of speech and expression, because what is the meaning of freedom if I don't get the real information? Okay, that is a meaningful freedom of speech and expression involved. I should be informed about what is happening within the government, then only there is a meaning to it. Okay, so first is right to information. Yes, second is, yes, freedom of press. Freedom of press. Freedom of speech and expression also involves right to privacy. Freedom of speech and expression also involves, अगर ये freedom of speech and expression ऐसा नहीं है कि आपको गवर्नमेंट ओपिनियन के लिए मतलब आपको गला घोट देगा बताओ करके, ठीक है. It is your right to remain silent also. Okay, so it's the negative right also, that is a freedom to remain silent. In fact, this was been debated in case of right to life. Does the right to life also include right to death? तो तब जो पिटिशनर ने फाइल किया गया था तो उन्होंने बोला कि आपने तो यहाँ पे लगा दिया था कि that negative is also a right, because when in this particular case, try and understand what is written, freedom of speech and expression. You have also granted its negative side, that is a freedom to remain silent, which is a negative connotation of this. So petition was filed, right to life, why it should not be right to death? Okay, then grant us a death. Particularly this was a case of Santhara. Santhara pata hai? Okay, yes, that is a practice of a Jain. So right to death can be a, then in case of a euthanasia also, yes, mercy killing. So that right also should be granted, but court has said no, this is very different from the ending the life, because there are other things which are involved. Okay, so we will see that later in case of Article 21. But here it is there, that is silent. Then fifth one is freedom, yes, freedom to demonstrate or host a national flag. Hoist a national flag. That is also freedom of speech. Okay, you can hoist a national flag also. So these are some of the implicit freedoms which are the part of freedom of speech and expression. Now, related with the assembly, some of the things related with the assembly. Now, there is a peaceful assembly. Yes, you can have the peaceful assembly. What are the 2 exceptions? That it should not hamper the sovereignty and integrity, and it should not hamper the public order. So, are the caste rallies जो है, assemble, caste rallies are permitted. Caste rallies, that's also an assembly, that's also a peaceful assembly, if they are not coming up with the guns and bullets. Yes, they should be permitted, but Allahabad, that is a Lucknow bench of Allahabad High Court, recently banned the, recently मतलब हाँ काफ़ी 1-2 साल पहले हुआ होगा. So they have banned the caste rallies, quoting that freedom of, वो जो exception है, public order, it is disturbing the public order and it is creating the animosity amongst the different castes. To that extent, that's true also, public order every time whenever the caste specific group is coming, the another caste is also coming, the another caste is also coming, and then there is a chaos, and therefore there is a public order. But they are also stating that this is a peaceful assembly, and there is no provision that you cannot have the assembly on the basis of caste. Okay, so therefore this debate is going on. High Court has given the verdict. It will go to the Supreme Court and things will happen. But that's one of the things that caste rallies are permissible. That's otherwise an important part in case of means, if such questions can be asked. Okay, but just remember that there are only two exceptions. In case of association, association यहाँ पे पूरा जो क्या है, freedom of association, trade union or union. One more, yes. In fact, this has been revised. Okay, that is and cooperatives. कौन सा amendment है ये? 97th. Okay, so the word cooperatives has been added by 97th Constitutional Amendment Act. So formation of cooperatives now become your fundamental right. Okay, so that's your fundamental right. Initially, the word was freedom of association and unions. Now, yes, tell me the strikes, that trade union के जो strikes है, are they permissible or are they not permissible? हाँ हाँ, yes, there are two exceptions obviously. What are the two exceptions? That is a sovereignty, then second is public order, and there is a third also, that is a morality. Yes, with this provision also, can they go for the strike? Yes, Industrial Dispute Act gives them the right. Okay, trade union, they can go for the, obviously the peaceful, okay, and all those things, so they can go for the strike under the Industrial Dispute Act. Now, can the government servants go for the strike? Can they go for the strike? Are you sure? Can government go for the strike? Why there is a difference then? Trade union or government में क्या difference है? हाँ, association, हाँ, government association. That is what I'm saying. Yes, you are right. Why trade association have the right and why government service association should not have the right? Huh? Trade unions are employed by? Yes, they are the pressure groups. Okay, so there is association, but here the whole functionary will go. But the Supreme Court's one of the verdict says that government servants can go for the strike as a last resort when all peaceful means of negotiation have ended. So there is a lot of complexity there. Okay, first you need to show that so many times you have crawled in front of the government to increase the wages or whatever the thing is, and it has not happened, then it is used as a last resort. That's the one thing. Second, government reserves the chance of going through the ISMA, जो essential maintenance of the services act hai. So say for example, if the doctors in the government has gone for the strike, so obviously they can, because that's an essential service. So in that regard, there are a lot many cases and Supreme Court verdict, but by and large you can remember any kind of the peaceful, so long as this 2-3 have not been restricted, you can go for it. Again, remember, जो भी reasonable restrictions है, remember, these are only the provisions, 1, 2, 3, 4 जो है. It is for the judiciary to interpret what it is, and there has to be certain law regarding it. Are you understanding? These mere provisions will not, matlab on the basis of assumptions, the rights will not be taken up. Okay, Supreme Court will say that whether a particular act will fall under the, कई बार ये होता है कि freedom of speech and expression, immediately we scold someone, you should not have said it because freedom of speech and expression do not allow you to do so. Okay, now this is your maybe subjective interpretation ki it will not come. Maybe the court will tomorrow say that no, we didn't find it, it is a part of these 8 points. Are you understanding? So it is for the court to decide whether any single act really come under a restriction. So it means that the people cannot stop the rest of the people from having and enjoying the space they have. Are you understanding? or even for that matter the legislature and the executives also. The Supreme Court will be the final arbiter to decide, okay, anything fall under the reasonable restriction or not. Say for example in case of JNU, so much of thing is happening. Finally it is for the Supreme Court to say that whether the freedom of speech and expression has been violated or not. Okay, so kahan tak chale gaye the hum? Yes, cooperatives and this thing has happened. Movement and settlement we have already explained. Profession, there is nothing much to explain. Okay, so these are the aspect of Article 19. Okay, shall we conclude here? Okay, so for the time being today's fundamental rights is over till 19. Okay, please थोड़ा सा मतलब पढ़ के भी आओ, मतलब that will be good because you will also समझ रहा है क्लास में, मतलब whatever is happening. Okay, tomorrow there will be test. Tomorrow we will finish rest of the article also, because today to bring the tempo we have discussed the theoretical part also. Tomorrow fundamental rights, directive principles and fundamental duties, three things will be covered, and then at the end of the session there will be a small test, mini test. ठीक है? Thank you so much. Have a great day.